I'd like to call the meeting to order. This of the Tennessee State Board of Accountancy. This meeting has been properly noticed, and the agendas were posted on the board's website on April the 29th. A couple of announcements I'd like to make first this morning. First, we'd like to thank Charlene for her service to the board. She has a greater calling, namely primarily grandchildren, that she's going to be moving to Massachusetts. She's opened her home to us anytime we want to go to Boston and have
Absolutely.
lobster and all
Absolutely.
that. Just keep that in mind. Keep her cell phone. And, thank you for your contributions to the board.
It's been my pleasure.
Thank you very much. I'd like to remind each of you today to lean forward and when you're speaking, and watch for the little light to come on, so that, because we're being recorded, so that the public has the ability to see what actually went on in all these meetings. A roll call vote will be required on everyone today, particularly since we have several on the conference call participating by phone for various reasons. Karen will be calling your name, so please vote when your name is called. We have a guest with us this morning, Mr. Blofus, who is obviously Bill, would you kind of stand up here for us? Bill is what I guess I would call my mentor, and plowed some pretty rough fields that have provided the fertile ground that we have today. He was always, I've been on the board now for, I guess, right at 8 years, and Bill, to me, has been one that's never been afraid to not be the yes man. But he wasn't the kind of guy either that would just talk to hear his head rattle. He always had a legitimate point and was not ever afraid to speak his point. And I thank him for that. You set some standards for us. You had some rough roads when you were there, but you stuck through them. You kind of surprised us by deciding that you wanted to retire, but we certainly respect you. And we'd like to recognize you today for your fine service. And before I give you this little memento, which you've passed one on before yourself, I know there's others in the room that would like to share their appreciation as well. I've asked Brian, would you kind of came in the middle of all this, so
Sure. I'm terrible speaking. This mic's going to get closer, so I can't pull it toward me. But I just wanted to. I was great. I appreciate Chairman for letting me speak this morning. I had the opportunity to work with Bill in the last couple of years, and yeah, I've had the opportunity to work and get to know some fantastic people in my time and in my professional career. This included people like Senator Howard Baker, Governor Haslam, and those are people I hold in high esteem. And Bill, working with him is someone I put right up there in terms of integrity and leadership, and just feel so grateful that I had an opportunity to work with him. I think the legacy he's left for this board, his leadership for years to come, are going to be, I think the impact's much greater than he's felt. And just from a personal standpoint, working with, I can't quite look at you and say this, but it was both personally and professionally an incredible thing. And some things he did last year in terms of leadership, I think has helped set the course of this board in a great direction. The relationship we have with this board is at the best from a department standpoint. It's the best it's been since I've been a part of this administration. And I think that's a significant reason because of Bill. So I just wanted to say thank you publicly.
Thank you. I would also just like to say, Bill, incredible person to get to know, incredible amount of respect for your career, your private career, and then your just undying service to the profession, not only in this role, but just in the community here. You have big shoes to fill for this board. And for those of you that didn't have the opportunity to work with Bill or be on the board under his leadership, or at least not for very long, we have it kind of easy these days. And there's nothing more correct than what Don just said, that you plowed a lot of tough fields to leave some very fertile soil for us. And so I also want to thank you very much, and thank you for kind of taking me under your wing a little bit when I was new to the board and kind of helping me kind of see the ropes. I appreciate that. And thank you.
Well, you're an attorney. You needed extra help.
I did, and I appreciate it. I appreciate it.
Hey, Bill, this is Trey. I really did appreciate your support. You did a whole lot for this board, and I will forever be grateful for the support you gave me and the board. I can't say enough about all you've done for us, so I want to say I appreciate it too.
Very good, Trey. Thank you.
Bill, I want to read it later, but it's from the Tennessee Department of Commerce and Insurance, presented to William F. Blockfuss Jr. Treasured things, knowing that you've got friends and you made a
That's great. Thank you.
Thank
Great. A bunch of years ago, I was working on a farm in Kansas, $5 a day, 10 hours a day. But when you were baling hay, you got $1 an hour. And I could go to the very place in the alfalfa field when I was riding a trailer behind a baler that I resolved that I was not going to do that for the rest of my life. And so that led me to, my research said that I could, the best job I could get was in public accounting. If I could get a 4-year degree. And the profession has been incredibly good to me. And it's been a great experience. Serving on this board was a very good experience, payback hopefully in a small way to the profession. And I really have enjoyed working with all of you and the predecessors on the board. And particularly we added a little bit more interest to all those job in the past year or so. And thank Brian very much for the help that he and the administration have provided this board. So thank you very much. It's kind of you to come down here, and I guess I don't get mileage today. Thank you very much.
But you can get breakfast if you want to stop in the back.
Thank you, Bill.
And we invite you to spend the rest of the day with us if you'd like to. First order of business then would be for a roll call, please.
Janet Booker Davis,
Here.
Stephen Eldridge,
Here.
Larry Elmore,
Here.
Gay Moon,
Here.
Gabe Roberts,
Here.
Don Royston,
Here.
Charlene Spiceland,
Here.
Casey Stewart,
Here.
Trey Watkins,
Here.
Judy Weatherby,
Here.
Are there any additions or corrections to our agenda?
I have none, Mr. Chairman.
Then we'd like to move on to the next item there of the executive director position. Each of you know the new House bill passed. We're very proud of that and the actions, and very thankful for the Tennessee Society and Brad, who is not with us yet, but for not only helping in drafting that bill and sponsoring it, but carrying it through for us. Wendy Garvin has been our acting director, and with the new bill that allows us to hire someone in a permanent position that is not a CPA, we are now have the ability to make her job a permanent one. I'd like to open the floor for discussion if that's proper, or if we need the motion first, and we'll have. All right, I'd like to open the floor for discussion and comments. Probably the person, and I'd solicit the person that probably spends more time with her from the state standpoint than anyone. Brian McCormack, I would call on you.
Brian McCormack, Assistant Commissioner of the Tennessee Department of Commerce and Insurance, and it's my pleasure this morning to be here just to comment on the performance of Wendy as she's been in the role of acting director. And with the things that we focus on here, there are a number of things, but the primary things we focus on are timely licensing, efficient handling of our complaints, and quality customer service. Those are three of the primary things that I'm most concerned about. And in those three areas, just to give you an idea how the program's been doing since Wendy's been involved, from a licensing standpoint, they're achieving it was the most efficient rate for the department, or at least the regulatory boards division in terms of timeliness. And Wendy and her staff have done a fantastic job reducing that time to a significant amount from the previous years as we've been reviewing the last few months. Complaints are being handled very efficiently, and that process has been really buttoned down under her leadership. And then when it came to customer service, we have an internal process to evaluate customer service. We use a secret shopper, an audit process for some of our external communications that are managed by our internal audit office. And Wendy's group in this most recent evaluation of all our reg boards directors, her program had the highest score for the division. And this is, I believe, I'll just say I think this has a lot to do with her leadership and her attention. It's been a great pleasure for me to work with her from the standpoint, I shared some of this earlier, and I was involved in the process of interviewing with former Chairman Blofus and in that process. And we talked to a lot of exceptional candidates during that time. And I honestly am not sure you could have ended up with anybody better as an acting director. And I feel very strongly that the evidence from the data shows, but from a relationship standpoint, how she's engaging the industry and the way that she's keeping abreast of issues and understanding the issues and how to manage the various relationships that are impacted by this profession. To me, this is so I obviously don't get a vote here, but to me, this would be a no-brainer decision for you all to formalize and take advantage of the change in the statute to hire her permanently.
Thank you, Mr. McCormack. Do we have other discussion or comments?
Mr. Chairman, I have heard enough and seen enough. I would like to make a motion that we hire Wendy as our permanent executive director.
I would like to second that motion.
Have a motion and a second on the floor. Any discussion? And this would be at the same stated salary that we have budgeted for going forward until review time. Ms. Conlon, would you conduct a roll call vote, please?
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Motion carries. We all knew we wanted you, and thank you. And I will say that I have seen more continuity with the board, with the Department of Commerce and Insurance, communications, working together, and that's just a testament to the way you organize things, and certainly nothing beyond that. So thank you very much and welcome.
Thank you.
You all have each been presented a copy of the minutes for the February the 9th meeting. Are there additions or corrections to those minutes? Hearing none, I would entertain a motion that they be approved as presented.
So moved.
Do I have a second?
Second.
Ms. Conlon, would you conduct a roll call vote, please?
Janet Booker Davis,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Gay Moon,
Aye.
Gabe Roberts,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Motion carries. We're running ahead of schedule since yesterday was, since we were behind yesterday. So, you want to move?
Mr. Chairman, if we could have a few minutes break so that we can get set up for the formal hearing.
By all means. This meeting will stand in recess for 10 or 15 minutes till we can get the court reporter set up. Thank you.
If we're ready to proceed, you have a copy of the notice of hearing. All right, why don't you go ahead and pass that out. While Ms. Ryan passes this out, I'll go ahead and open the proceedings. This is a hearing before the Tennessee State Board of Accountancy to consider the matter of the Department of Commerce and Insurance versus Mr. Jerry Tipton as a result of the notice of hearing and charges that Ms. Ryan is handing to you right now. That notice was filed on February the 10th of 2016. My name is Tom Stovall, and I have been assigned by the Secretary of State to be the administrative judge at this hearing. As the administrative judge, I will not participate in the decision that's made on the merits of this case. That decision will be made by the members of the board that are present this morning. However, I will make all rulings of evidence, law, and procedure under the authority granted me by the Tennessee Administrative Procedures Act. Would the members of the board that are present and participating in this hearing today please identify themselves for the record? And perhaps, Ms. Ryan, should we start with the person on the telephone? All right, go ahead.
Stephen Eldridge.
All right. And sir, if there's any time during this hearing that you can't hear, please speak up, all right?
Thank you.
All right.
Gabe Roberts.
Judy Weatherby.
Janet Booker Davis.
Casey Stewart.
Don Royston.
Gay Moon.
Larry Elmore.
Charlene Spiceland.
Thank you. Members of the board are reminded that their decision in this matter must be based only upon the record that's produced during the course of this hearing this morning. Failure to abide by this instruction could result in the matter being reversed or remanded back to the board for further consideration should it be appealed to Chancery Court. We'll also ask at this time if any board member has received any ex parte communications concerning this matter or has any prior knowledge about the facts of this case or has any familiarity with the respondent, Jerry Tipton, and if so, please put that on the record at this time. All right, seeing none. Ms. Robin Ryan, Assistant General Counsel with the Department of Commerce and Insurance, represents the department in this matter. Mr. Jerry Tipton is present this morning and is not represented by counsel. And I spoke with Mr. Tipton briefly before we went on the record. Mr. Tipton, you understand you got a right to have an attorney, correct, sir?
Yes, sir.
And you want to proceed without counsel, is that correct, sir?
Yes.
All right. The record consists of the notice of hearing that the board members have in front of them at this time. We also have a notice of witness and exhibits filed by the department and a pre-hearing order that was entered by Judge Leonard Pogue on March the 7th of 2016. After the board members, I'll pause for a moment if all board members reviewed the notice at this point. All right, we're ready to proceed. Ryan, did you have an opening statement you wanted to make?
I do, Your Honor.
All right.
We are here this morning due to the actions of this respondent in the care of his clients. This matter was opened due to a complaint by one of his clients, Dana Caldwell and her husband. The proof will show that Caldwells had had their tax prepared by the respondent's office, and although apparently not by the respondent himself. You will learn that the problem for the Caldwells arose when they were notified that 3 years of their tax returns would be audited, and the proof will show that the cause of the problem was mileage that the Caldwells used in certain trips in Mr. Caldwell's role as a pastor. The evidence will show that as a result of that audit, the Caldwells were assessed civil penalties and interest. The proof will show that these returns were not reviewed by Mr. Tipton, and that he admits that there were mistakes made by his employees on these returns. The evidence will show that this matter was investigated, and then when the investigator went to review the files, the firm maintained only the copies of the W-2s and 1099s and the tax return, and that this respondent admitted to not reviewing any of the Caldwell's returns. The investigator will tell you that the document provided by Ms. Caldwell clearly showed that mileage by category, and that this issue was one that could have been addressed and corrected if it had properly been reviewed by this respondent. We assert that this failure was a failure to properly represent his clients using due professional care, especially as this issue could have been addressed and corrected prior to any review by the IRS. At the end of the hearing of all the proof in this matter, we ask that you find this respondent in violation of 62-1-111, violating the rules of professional conduct, that rule being 0020-03.08, and that as a result you assess a civil penalty appropriate to this violation, and that he therefore also be required to pay all the court costs in this matter. Thank you.
All right, Mr. Tipton, did you want to make an opening statement, or do you want to just reserve your comments until you testify?
Let's go wait, please.
All right, sir. Why don't you go ahead at this time? Would you administer the oath to Mr. Tipton, please? Raise your right hand, please.
Do you swear or affirm that the testimony you're about to give in the floor going?
Yes.
Thank you, sir. Go ahead, Ms. Ryan.
Call my first witness. This is Wendy Garvin.
All right. Would you raise your right hand, please, ma'am?
Do you swear or affirm that the testimony you're about to give in the floor?
I do. Ms. Garvin, would you please state your full name for the record?
Wendy Garvin,
And your position with the state of Tennessee?
Executive Director.
And I know that you were just again approved this morning, but prior to that, how long have you served as Executive Director?
For 9 months.
As the Executive Director, are you considered the keeper of the records of the department and those licensees in the department?
Yes.
Do you review complaints as they come in?
Yes.
And then are you the keeper of the license files and the complaint files? Once a complaint is filed, what's the next step?
We gather the information, we notify the respondent in writing, and request a response.
And then what happens?
Once we receive that response, that information is then forwarded to the complainant to give them an opportunity to provide an additional information.
And once you gather all the information from both the parties, is there a normal process of investigation, or is that just as it comes?
Within 45 days of receiving the complaint, we send all the information received to legal, and legal then reviews the information to determine if an investigation is necessary.
And the investigation, if it is necessary, is that something that's done within your department? Do you have investigators within your department?
Yes, we have an investigator on staff, yes.
Was there an investigation in this present matter?
Yes.
Okay. And was the complaint sent, in this case, to this respondent for a response?
Yes.
Okay. If after the investigation, what happens? Sorry.
After the investigation, the legal will evaluate the facts and circumstances. They will make a recommendation to the board, and the board will consider the facts and circumstances in that recommendation and make a decision.
Having said that, are the names included, or is this all anonymous?
It is anonymous.
And as a result of what is presented, what happens next? If there's a violation found.
If there's a violation, typically there's a consent order approved.
And if the party approves of consent order, then that resolves it. But what happens if they don't?
Typically we go to formal hearing.
And that's why we're here today. Is that correct? Okay. Then, as the executive director, are you familiar with the license file of Mr. Tipton?
Yes.
And the complaint file as well?
Yes.
When was he first licensed?
November of 1990.
Mm-hmm. And when you look at his history, does he have a complaint history at all?
There was a complaint filed in 1998 and disciplinary action was assessed.
And that's the only complaint on his file?
Correct.
Okay. In this particular case, what was the reason the complaint was opened?
Mr. and Mrs. Caldwell had their returns prepared by Mr. Tipton's firm over a number of years. They were then audited by the IRS, and it was found that certain mileage was claimed that was not appropriate, and they were assessed some penalties and interest.
And they filed the complaint based on that particular instance?
Yes.
And was it this complaint sent to Mr. Tipton?
Yes.
And what was his response?
May I?
Yes, you may.
Okay. Would you like me to read the response or?
Please.
Okay.
And the date as well.
Okay. The date of the response is December 23rd, 2014. My office received a call from Mrs. Caldwell regarding an audit letter she received. My son, who works with me, told her to give me a call back when the audit was scheduled and I would accompany them to the local office. She later called and said they went on their own to the audit and she informed me of the result. I have never seen any correspondence on the audit and was never sure of the amount due. I also never knew of the amount of interest due because Ms. Caldwell wanted me to pay the entire balance due as per the audit findings. There was a mistake made by the employees that prepared the returns regarding the computing mileage. I never advised her to call and tell the IRS that her husband had an office in their home. During a later conversation, it was my understanding her husband has an office in their home, and I offered to amend their returns. Regarding the computing mileage, I never meant to imply to Mrs. Caldwell that we do all pastors' returns this way. I actually thought the audit only covered 2012 and 2013, and I offered to reimburse her $300 and would have offered more if I had known the actual amount of the interest due. I have discussed with my employees again the computing mileage rules during our recent training meetings to assure that this will not happen in the future. I have had a good relationship with the couple, and I'm deeply sorry for the problems this has caused them. My policy has always been to accompany my clients to audits and reimburse them for penalties and interest caused by any errors made on their returns.
Now, in this particular matter, the audit, none of that is relevant. It's the issue of the fact that returns were prepared and not reviewed. Is that right?
Correct.
And do you know how many returns were prepared by Mr. Tipton's office that were not reviewed?
She claims in her complaint that for 3 years.
Was there an investigation in this matter?
Yes.
And what was the result of that investigation?
May I refer to my notes?
Yes.
May I read the investigator's remarks?
Let me ask a question first.
Okay.
Who did the investigation?
Our investigator, Don Mills.
Okay, and he's here to testify today.
Correct.
Is he a CPA?
Yes.
So what is his role in investigations?
His role in investigations is to gather the facts and circumstances and to evaluate whether there was a violation of any laws or rules.
In his review, then he gathered that, and he issued a comment about what he thought were or were not the violations?
Correct.
And what was his conclusion?
His conclusion was that the respondent's failure to review his client's return and to ensure that his staff was adequately trained is both evident and admitted by the respondent.
What laws govern when an action can be taken against a licensee for violations of this sort?
That is under our laws in 62-1-111.
What does that provide?
It provides for the revocation, suspension, or refusal of license.
Can you read, if you would, will you read 111A and then 6 and 7? Please?
Sure. After notice and hearing pursuant to 62-1-120, the board may revoke any license issued under 62-1-107, 62-1-108, or 62-1-109, or corresponding provisions of prior law, may suspend the license or refuse to renew the license for a period of no more than 5 years, may reprimand, censure, or limit the scope of practice of any licensee, may impose a civil penalty, or may place any licensee on probation, all with or without terms, conditions, and limitations for any one or more of the following reasons. 6. Violation of any provision of this chapter or rule promulgated by the board under this chapter or violation of professional standards. Number 7. Violation of any rule of professional conduct promulgated by this board.
What are the professional standards covered in the law?
They are covered in our rules, chapter 3.
And what particular rule?
That would be 0020-03-.07 competence.
And what does that rule state?
A licensee shall comply with the following standards and with any interpretations thereof by bodies designated by the AICPA or by other entities having similar generally recognized authority. B. Due professional care. Exercise due professional care in the performance of professional services.
What is the AICPA?
The American Institute of CPAs.
And so there's a requirement for state licensees then to follow the rules and regulations of the AICPA. Is that right?
The Code of Professional Conduct.
And what is the standard for professional care in the AICPA?
Due professional care.
The outline of what it means or doesn't mean?
There are several pieces that are incorporated in due professional care, one of which is due care to plan and supervise. So performance of services.
Okay. So in any event, then there's a responsibility to supervise based on not only our law, but the requirements and the standards from the due professional care of the AICPA?
Correct.
Okay. Excuse me. Now, you mentioned earlier that this body has the power based on 62-1 and 111 to do a variety of things, including suspension, revocation, including a suspension for 5 years, an oversight, and also just plain civil penalties. Is that correct?
Correct.
So it's not a requirement to do everything.
Correct.
Okay. It depends on the severity, I would imagine, of the issue at hand. Is that right?
Correct.
Okay. Now, in this particular matter, there was a conclusion based by the investigator concerning the professional care in this case. I think you just read that, right?
Yes.
Okay. Let me ask this. Has been there a history from this board reviewing due professional care in the past and what would be considered a violation? That is, have there been civil penalties assessed for that?
Yes.
Anything recent?
I believe the most recent one was in 2013.
And it was based on this particular violation?
Correct.
A violation of due care.
Correct.
So there is a history of the board finding, in that particular case, was the license revoked or just a civil penalty?
No, just a civil penalty.
Okay. Since this matter has been filed, have there been any other complaints opened up against this respondent?
No.
Okay. Now, when the matter was prepared and he addressed it, was that address sent to Ms. Caldwell for her review?
Yes.
Did she respond to that?
She did.
Can you read her response, please?
Yes. To whom it may concern, I received a copy of Jerry Tipton's response letter and would like to follow up concerning his claims. I spoke with Jerry Tipton's son after receiving the letter to be audited and even went by their office so they could make a copy of audit letter and dates and information needed. We had to cancel original date due to the birth of our child and informed him of new dates. We attended the audit and Jerry Tipton told us he would try to make it and never showed up. His next comment was he never knew the amount of penalties. I called him with the results of the audit, with the exact amount we had to pay, and this is when he informed me to call them back and tell them we have a home office and see if that would change how the mileage was counted, thus saving us on penalties. I consulted a family member and they informed me this would open a can of worms, and to have a home office, you must jump through hoops and would probably cause more harm than help. His next paragraph says he did not mention to imply that they do all pastors' returns this way, but when the auditor with the IRS showed us in black and white the law for counting mileage, Jerry Tipton said it was a gray law, and this is how they do all their pastors' returns. I again called Mr. Tipton concerning the fees we were to pay, gave him the exact amounts, and he was very clear he would give us $300, and that is all, even though I clearly told him this was the amount, about 10% of that this was only about 10% of what we even owe. He said that this is all he would pay, and he usually only pays the interest when clients have to pay. My husband and I neither have enough knowledge where we feel competent enough to do our own taxes, which is why we have counted on Jerry Tipton's office. Each year we have taken in a sheet of paper that clearly states miles for trips for AM and PM Sunday and Wednesday services, plus hospital trips, etc., and have counted on them to file correctly. Never once have they told us that we should not count trips to and from home, and would have welcomed the correction so all this could have been avoided. I think it is outrageous that he refuses to pay for mistakes his business caused. Let me know if there's anything else I can provide at this time.
And what's the date of that response?
She does not have a date.
Have you heard from her since then?
No.
And this was sent after the response in December 2015 of
Correct.
Mr. Tipton? Okay. And it would appear the issue there was the mileage that caused the problem.
Correct.
Is that correct? Okay. May I approach the witness, Your Honor?
This appears to be the new matter transmittal to legal with the complaint and the responses.
Thank you, Your Honor. If may, can I pass that out and have that? That is my first exhibit.
Number one, did you provide a copy to Mr. Tipton? All right. Let's give them a moment to look at that. Sorry, Ms. Ryan, did you say you had other exhibits?
Yes, they're all a part of what she's already testified to. The
All
second
right.
is my.
Why don't we go ahead then? I'm sorry. Let's go ahead and put them all in, and then we'll just let them review these exhibits. All right.
This is Mr. Tipton's response to the complaint.
And this document as well.
This is Mrs. Caldwell's response to Mr. Tipton's response.
Let's make that a collected exhibit number 2, 2 documents.
All right. That'll be fine. That'll be exhibit number 2. Are those all your exhibits? Okay. All right. So members of the board will allow you all an opportunity to review these documents before we proceed. All right, Ms. Ryan, you can proceed.
That concludes.
All right, Mr. Tipton, do you have any questions for Ms. Garvin?
Yes, I would just like to ask her just on the incident back in 1998, if she had something on that. I'm just kind of curious about that. You know who it was, if she could tell me. I mean, she happens to know right now. I mean, I never did hear anything about it or anything.
I do have the complaint file with me.
Okay. Tell me who.
Just a moment. I have a consent order here dated May 1999. Agreed to a consent order that imposed a $1,000 penalty, 16 hours of CPE, and compilation review and a peer review to be scheduled in 90 days.
I don't remember, but I mean, it's okay, though. I'm just curious. That's fine.
All right, anything else, Mr. Tipton, for Ms. Garvin?
I just on, let's see, from her, no, I don't think so.
Thank you, sir.
Okay.
Ms. Ryan, any redirect?
Yes, that particular instance also due to professional care issue, or was it something entirely different?
There was due professional care.
Was it a supervising, or was there something different in that?
It was in the performance of a test engagement.
Okay.
All right. Anything else? Anything
that's all
else?
for her.
Mr. Tipton?
Thank you.
No. All right. Members of the board, questions for Ms. Garvin?
May I ask a quick question? In reviewing the letter from the state of Tennessee, dated December 9th, 2014, it refers to a notification sent to Mr. Goldstein. Who is that?
I noticed that as well, and I believe that's a typo. I am not aware that was part of this case.
Okay, I didn't see anything related, so I was not sure.
All right, anything else from Ms. Garvin?
I have a quick question. Did the Caldwells, did we ask? Did you speak with the Caldwells specifically, or is the only communication that was had between Commerce and Insurance and them the formal letter of communications that back and forth that we have as exhibits?
I did not speak with them, and I'm not sure if the investigator did.
Do you know personally if they were ever invited to participate in this formal hearing today? Okay.
Anything else from Ms. Garvin? No? Thank you, ma'am. Ms. Ryan, going to call the next witness?
I call Don Mills. Be sure you speak into the microphone if you would. Would you please state your full name for the record?
Donald A. Mills.
And your position with the state of Tennessee?
I'm an investigator.
For a particular department?
Just for the Board of Accountancy.
And how long have you done that role?
Since 2009.
Are you also a licensee?
Yes, I am.
So that means you're a CPA?
I am a CPA.
And what do you do as an investigator for the accountancy board?
I basically work at the direction of board counsel on investigation on complaints that have been given to me for follow-up and to finalize investigations and present a report back to council.
And how many investigations do you typically do per year?
I think we average about 82 complaints per year.
And in this particular case, were you asked to do an investigation?
I was.
And when did that investigation take place?
April of 2015.
On a particular date?
April 15th.
And what were the allegations?
That the respondent had failed to exercise due professional care in the preparation of a tax return of the complainant. There were several smaller allegations made that were not substantiated.
Meaning?
I had no documentation from either the complainant nor the respondent that anything that was being alleged had actually occurred.
On the day that you investigated this, how many people were in the office?
To the best of my recollection, there were probably 6 to 8 people in there.
Do you know how many of them were licensees?
I think Mr. Tipton had told me he was the only CPA.
Was he cooperative that day with you?
He was. Considering I was there on April the 15th, he was most cordial.
And what did you look for in your investigation in this matter?
Well, basically, I was just trying to substantiate the allegation of failure to provide the correct answers on the tax return.
And what did you do in order to address that question?
Well, I had asked Mr. Tipton to see the tax file of the complainant to, see what it contained. He informed me that basically, and this is kind of a usual practice nowadays, the documents are scanned into, say, a practitioner's file. And he said that the tax file basically just consisted of W-2s, 1099s, anything to that effect. And, of course, these returns are e-filed as well.
So did you review any of that?
I did not.
Okay. Did you speak with the complainant?
I did.
And what did she tell you?
She made several assertions, which, as I said earlier, really could not be substantiated. The one thing I asked of her is, could she prove And did she have documentation regarding the mileage that had been questioned by the IRS?
And did she have documentation for that?
She did.
And did she provide that to you?
She did.
Okay. And after you reviewed that, or did you do it at the same time? Did you then talk again to Mr. Tipton, or no?
I had already talked to Mr. Tipton.
And what statements did he make to you?
Well, basically, I'd asked him to sign an affidavit stating that what he had made in his original response was true and correct, which he did.
And that's the letter we were speaking, that was read into the record earlier?
That's correct.
Okay.
Mm-hmm.
Did he say anything else to you?
He told me that he did not review the return and he didn't sign it.
Okay. Did he tell you who did prepare it and if there was a signature at all?
We did not discuss who in his office had prepared it.
Well, when you looked at all the documents and you looked at all that, what was included on concerning the mileage that should not have been included?
Commuting mileage. If you look at the documentation provided by the complainant, it was obvious that it was commuting mileage for the most part.
Did Mr. Tipton have any explanation for why that mileage was included or not addressed?
Well, he simply stated it was a mistake.
And do you know how many years this mistake went on?
I do not.
Do you know it was more than 1 year tax returns?
I do not know that.
After you reviewed everything, did you reach a conclusion?
Well, my conclusion was basically that the respondent had failed to conduct his tax practice in what we would consider to be a professional manner by not reviewing the work of others.
Okay, so it's based on not reviewing the work of the others.
Correct.
And on what laws or rules did you come to that conclusion?
I have some specific ones, if I might be allowed to review those. What I basically looked at, first of all, for applicability, Rule 0020-03.02 applicability, which says that the licensee shall comply with the AICPA Code of Conduct when these rules are silent on any matter. So by that, I went into the, the AICPA Code of Professional Conduct, Section 91 applicability. If I could read just a section of that, it says a member shall not knowingly permit a person whom the member has the authority or capacity to control to carry out acts which, if carried out by the member, would place the member in violation of the rules. And further, a member may be held responsible for the acts of all persons associated with him or her in the practice of public accounting whom the member has the authority or capacity to control.
So in your report itself, I believe your conclusion was that there was, and I'm reading this and you can correct me, there was direct evidence that mistakes in the return could have been corrected if the work had been reviewed by an experienced tax preparer, or if the staff had been trained. Was that your conclusion?
It was.
Because the issue of mileage is a...
Well, I think someone with Mr. Tipton's experience, he would have noticed it immediately.
So somebody with the experience of a licensee would have noticed it where somebody else might not have recognized that.
I think so.
Have you spoke to Ms. Caldwell at all since that one time?
I have not.
And we know that she went to an audit and received a civil penalty and interest, but you don't know how much. Do you know?
I don't know. She did not provide any answers to those.
But she did provide you a document to show about the mileage?
She did.
May I approach the witness, Your Honor?
Yes, it is.
And what does it show?
Well, it has a list of various expenses which would be related to, and I want to tell the board that this person is in fact, the spouse of the person who brought the complaint is a church pastor, so they were doing church expenses, et cetera, et cetera. About mid-page there, you see the mileage, and it's broken out into several categories. Weekly services, revivals, etc., and then hospitals, which of course is part of their job would be going to the hospitals to visit the sick and et cetera, et cetera. So it was broken out sufficiently that I could determine that weekly services is commuting mileage. And of course, that wouldn't be included in the total.
So with this documentation, it would have been easy to, if someone reviewed it, to see, yes, some of the mileage would have been appropriate and some of the mileage would not.
In my opinion, yes.
And I'm going to ask you if you can identify this document for me.
This is a copy of my investigative report.
Thank you. May I?
Yes, this will be exhibit number 3. You would pass that, mark it, and then pass it to the board, please. Why don't you go ahead, please?
Yes, I have a couple more other questions. Now, included in your report was the copy of the letter from Mr. Tipton in December. Is that right?
That's correct.
And an affidavit swearing to that letter, correct?
Correct.
And the letter in it, he says, in the matter of the tax years 2012, 2011, 2013.
Correct.
And it is from the letter then you're coming from the mistakes that the employees miscalculated the mileage. Is that correct?
That's correct.
Did he provide any other statements to you at all, or any other information that could have cleared this or changed this?
Well, he did say that he had attempted to train the employees after finding out about the mistake to correct this in the future.
Did he say why it took 3 years to find the mistake?
He did not to me.
So did he say whether or not he reviewed the return in 2011 or 2012?
We simply dealt with the most current tax return.
Which was the 2013?
That's correct.
But he didn't offer any explanation for the other years either.
We did not discuss that, no.
I have nothing further for this witness.
Right, Mr. Tipton, questions for Mr. Mills?
Yes, it's actually just for the record. He was out on the 15th and was busy, and he offered.
Mr. Tipton, you'll have an opportunity to testify in a moment. Right now, it said, "Do you have any questions for Mr. Mills?"
For questions, no.
Okay, thank you, sir. Members of the board, questions for Mr. Mills?
Have maybe a couple of questions. Mr. Mills, I think it's been testified that the respondent did not sign the tax return, review it, or sign it. Do you know who did sign the return?
No, sir, I don't.
Do you know if that individual was, well, I guess maybe you've answered that question. I guess what I would like to know is whether the person that signed the return was qualified to sign a return. In other words, were they an enrolled agent? Did they, to practice before the IRS, did they have the authority to sign the return? Do we know that?
No, sir, I don't.
Okay.
I have a couple questions. Mr. Mills, on the complaint that's in this packet, I guess it was just entered into as an exhibit, the Caldwells are identified as the complainants, and then it asks what's the name of your employer, and it says Estes Express Lines. And my understanding is that at least one of these individuals is a pastor. Do you know what is Estes Express Lines, and what's that employer relationship with the Caldwells?
That would be a W-2 employer of Mrs. Caldwell's, my understanding.
That employer has no bearing on this case. It's just an identification piece. Is that right?
Correct.
Okay. Do you have to have a CPA license in Tennessee to prepare and submit a tax return for someone?
No, you don't.
In our rules, the word about professional services, I guess it's been testified to and is included in the, I think it's in the notice of hearing. It talks about how the allegations Mr. Tipton didn't conduct himself with due care in performing professional services. That's a paraphrase, but I believe that's a relevant paraphrase. Does the term professional services in our rule, to your knowledge as an investigator, include preparing and submitting tax returns?
Yes, it does.
It does?
The rule, yes.
So my question, I don't know if you can answer this, but if Mr. Tipton wasn't a licensee, would there be a basis for some type of action by this board to take against him?
No, sir.
So he's only here before us in the formal hearing because he has a license for this board?
That would be my assumption, yes.
And so the substance of what he did or the substance of this complaint would not be something that would otherwise be within our purview?
In my opinion, it wouldn't.
Do you know, maybe based on your experience, I guess, or because you're a licensee, what is required of a non-licensee who submits a tax return for their client and that client gets audited by the IRS? Is there some type of industry standard or professional duty that they owe that client to represent them in the audit?
There is not. Most practitioners do wish to represent their clients.
I think that's all I've got.
I have a question, Mr. Mills. In your investigation, were you able to determine whether the pastor had an office provided to him at the church, or did he maintain his official office at his home?
I'd requested any information regarding that or any documentation from the complainant, and I did not receive anything that was substantiated in either direction.
I think that would speak to the issue of the home office if he were not provided that official office at the church.
Can I ask a question? Did he get a W-2 from the church that might show if he had a housing allowance on
I,
W-2? Do you know that?
no, I did not review the tax return itself.
No.
Sorry, I do have one other question. Did you, or if not you, do you have personal knowledge that anyone else actually invited the Caldwells to participate in this hearing today?
It's my understanding they were invited.
Okay.
That's hearsay.
Okay, so I'm asking, did you actually talk to them, or did you ask them to show up today?
I did not.
This may have already been asked. I'm not completely sure, but do we know? We don't know who signed the return. Is that correct?
I did not know.
Okay. What have you been provided the name of Mr. Tipton's son? That
Not to my
there's
knowledge.
references to his son in this
Correct.
document. We don't know his name.
I don't recall it if I knew it.
Mr. Mills, I have a couple of questions, and you may have already answered it in a roundabout way, but we don't know if the return was e-filed or paper filed.
I assumed it was e-filed. I believe we discussed that at the time.
So the e-file, the ERO would own the office and the electronic return originator, and would be under Mr. Tipton's name. Am I correct in that?
That's my assumption, yes.
So he has ultimate responsibility for whatever goes out of his office under the ERO designation, regardless of the P10 number of the person that prepared the return.
Correct.
Okay, I just wanted that point of clarification. Now, Ms. Garvin, from the case file earlier, said that there was a compilation problem with the, and I just want to clarify this, with the original 99 complaint. In yours, you had a little more time to do the research. On page A3, you indicate that it was for practicing without a firm permit. And I just want to clarify so that we have no confusion what the, and it could be the same answer, but I just want further confusion taken out of it so that we know what the original firm complaint was and agreed upon consent order in 99.
I based my reference to that on the old RBS. If you look back at G2 under the notes, it basically maintains or tries to maintain a history of any disciplinary action. If you look to the last three lines on G2, practicing without a firm, that means firm permit. Paid $1,000 civil penalty, needs 16 hours CPE and review and compilation and a peer review. And it gives the complaint number. So considering that had already been filed away, I did not pull the complaint.
Likely floated down the river in the flood.
It's very likely.
Mr. Mills, I would
Thank you.
again like to make it clear that do we know anything about the experience or qualifications of the person that actually prepared and signed the return, qualified and had the requisite experience to do that?
I did not go into that, no.
Is the reason you didn't go into that in your field work because that person wasn't a licensee?
I did not go into that because the complainant was a CPA and it was his office and his responsibility. So I did not feel that it was that I had any real reason to go into the staff members.
I guess my question is, did you do any independent confirmation that there in fact wasn't another licensee on the staff?
I did not.
Mr. Mills, did you speak with the Caldwells?
I spoke with Mrs. Caldwell.
And was her complaint about the fact that they had to pay the money? And so I guess I'm asking, they weren't complaining about the professional due diligence. They were they, or was their complaint because they ended up having to pay the fees?
They had multiple allegations that they had to pay the fees, that they were audited, that they felt that, you know, they'd been misrepresented, various and sundry things. If you look at the original complaint, they had several allegations. As I said, the only thing that I could find any kind of documentation for was the fact that the mileage on that return had been incorrectly entered.
Sorry, I keep asking questions. One other one though, I'm just trying to make sure I'm clear, and I don't think I understood the answer to Mr. Royson's question. Is this a complaint against Mr. Tipton as a CPA, or is it a claim against Mr. Tipton's firm permit?
I'm not sure we differentiated, but the fact that he is a licensee and has employees is basically the same as if he had a permit and had employees. I don't think that the Code of Professional Conduct really addresses the difference between an individual, a sole proprietor, a partnership, only that the responsibility is with the licensee.
So, do you know if he has a firm permit?
He does have a firm permit.
You can see are you saying that under our rules about professional conduct and due care and providing professional services, if a staff person or unrelated person to the actual CPA fails to do that, then the CPA and not the firm is responsible for that? Is that what you're saying?
That's correct.
I have one more question. On the mileage, the issue is that the mileage was not from to and from the church, but from to and from their home. Is that correct? On the hospital visits.
The hospital visits were not in question. The question was the commuting mileage. In other words, going from home to the church for services, that's deemed as commuting mileage by the IRS, and you know. Does that answer your question? I'm sorry.
So it's the 12,000 miles in the beginning that says weekly services. That was, we have no documentation at all from the IRS, correct? We didn't.
Right.
We don't have the tax return. We don't have the
results
of their audit. We have nothing. So we are assuming it's just the weekly services mileage that was argued with as far as the IRS, or is it all of these? I guess I was just.
Well, I don't think it would be all of them. I guess
because the hospitals were to and from the church.
I think they are beyond the commuting miles.
Okay.
So the commuting miles, just to clarify, is that only for the weekly services, or is that a daily commute to and from an office at the church? I'd like to clarify that.
It wasn't broken out, just said weekly services. Regardless of if you go back and forth to the church, you're commuting. So, you know, even really with the revivals, Vacation Bible School, that sort of thing, you know, you're going to your place of employment.
Anything else? Excuse me. Anything else from the board for Mr. Mills? No? Thank you, sir. Well, Ms. Ryan, go ahead.
Is it your understanding it was employees of Mr. Tipton in his role as a CPA that prepared these returns?
Right.
And they were under his direction. Is that right? They were employees.
Yes.
And he was the only CPA in the office as far as you know.
Right.
Now, if a person is not certified, do they have to sign the tax return if they prepare it?
No.
So it could have been prepared for them and not signed by anyone?
It would have to have been prepared and signed by someone.
Okay. So someone, but including the individual as opposed to the unlicensed person? Or would there have been a signature from someone from his office on the return?
Well, e-filing doesn't generate a signature per se. It goes back to the PIN numbers and the originator of the return, et cetera, et cetera.
So, but it was in this particular office, while there's maybe a firm license, this is the only CPA in the office.
My knowledge.
And it's your understanding, according to the rules of the AICPA and the laws and rules of the state of Tennessee, the licensee has a responsibility for those working under him.
Yes.
And so the issue here today is that there wasn't enough supervision. Is this correct? Because mileage was an error on at least, well, he even says 3 returns.
Correct.
And what we have is the proof for one of them for sure, which shows that there was mileage going back and forth to church that was included that should not have been included.
That's correct.
And so all the other issues that Ms. Caldwell may have raised are not important to the matter at this point. It was the issue, like the home office, that wasn't an issue.
In my opinion, it wasn't an issue.
The only issue was the mileage.
Correct.
And the mileage was definitely wrong.
Correct.
Thank you.
All right, Ms. Tipton, questions for Mr. Mills?
I don't have any kind of questions. I just want to say that he was actually nice.
Objection.
Okay, Mr. Tipton. If you don't have any questions for Mr. Mills, then we'll that's all right. That's all right. Then you'll have an opportunity in a moment.
I mean, I have a question. I'm not sure whether it is actually a question or not, so I don't have any.
All right, okay, fine. Thank you, sir. You can take your seat, Mr. Step down, Mr. Mills.
Thank you, Your Honor.
One more witness.
All right.
Vanessa Huntsman.
Ms. Huntsman.
Would you please state your full name for the record?
Vanessa Huntsman.
And what's your position with the state of Tennessee?
I'm a paralegal with the Department of Commerce and Insurance.
And are you particularly paralegal for this particular board?
Yes, ma'am.
Have we had any communication from the Caldwells in this matter?
Yes, ma'am. We reached out to Mrs. Caldwell and to see if she could come in for the hearing. She stated that she would not be able to come in, but would be willing to help. An affidavit was forwarded to her April the 22nd, I believe. And we had no further communication with Mrs. Caldwell until late yesterday afternoon when she forwarded the affidavit back.
And under the laws of the APD, an affidavit has to be something presented prior to the time for the opportunity for the, so was it too late at that point to, thank you. And we've not heard, did you hear from her at all after that communication? Have you heard from her at all? Have you heard from her any prior to that? Thank you. That's all my questions.
Questions for Ms. Huntsman?
No, I don't have questions.
Questions for Ms. Huntsman? No? Thank you, ma'am. Any other proof, Ms. Ryan?
That concludes the state's proof.
All right. Mr. Chairman, members of the board, why don't we take 5 minutes and then we'll come back and then Mr. Tipton have an opportunity to make his presentation to the board and then he'll be open for any questions that might be directed his way. All right?
Thank you.
All right, Mr. Tipton, now it's your opportunity to say anything you wish about this matter, and then after you've made whatever statement you wish, then I'm sure that Ms. Ryan will have some questions for you, and then members of the board will probably have some questions for you as well. So go ahead, sir.
First of all, board members, I'm awful sorry that I'm actually here today. I did not know that I was, I mean, this was the only, just the only case y'all was going to hear. So I'm actually wasting just here wasting everyone's time, and I'm just awful sorry for that. I would have, paid the fine, moved on if I'd known I was going to be the only one today. So I'm awful sorry that I'm here now, I guess. Just something that I was said just for Mr. Mills. He was awful nice enough just to come back on the 16th of April, since it was the 15th. He was in town overnight, so he was actually back out on the 16th also. And we had a discussion about it. And so at the end, I asked him, I said, what do you think just on the outcome it is going to be. And he said it's just going to be a case, I believe, of just
I'm going to object to it.
Just you don't need to tell us what Mr. Mills said to you, Mr. Tipton. Just say whatever you wish about the circumstances surrounding this.
I think it's important, what he said to me, because that's the reason that I'm here today.
All right, go ahead, Mr. Tipton.
Okay, he actually said that he really thought it was a case of hearsay, she said, and it was just a misunderstanding, and that would probably be the end of it. So, let's see, then, when this happened, and I had the fine, I was kindly here today just to get some understanding and some guidance about this matter, I believe.
So, Ryan, why don't you just go ahead and ask Mr. Tipton some questions?
Mr. Tipton, isn't it true though you requested the hearing today because you didn't want to resolve? Okay.
Yes, but I didn't know what was going to be. I mean, how I mean, it actually worked or anything. I didn't know I was going to be on the case, or I wouldn't have really. I guess.
Are you saying that at this point in the hearing you would be amenable to signing an agreed order containing the terms that was presented to you earlier?
I'm already here now, so
okay.
I'm going to have
Just
my say,
making sure.
I guess, since I'm here and everybody else is here too.
You did not review the tax returns, did you, of Ms. Caldwell for 2011, 12, or 13?
Correct, I did not.
But how many employees do you have?
You mean just preparers, telephone girls, or everybody?
Preparers, people who do that work for you.
Probably about 35.
And they do it in your office?
Yes.
And you pay them all to do the work?
Yes.
And they are under your direction?
Yes.
And they're under your control?
For the most part, yes.
And you are the one who educates them on what is a proper or improper use of deductions and et cetera for tax returns?
We have training classes, yes.
And they prepare the returns, but you don't sign them?
Oh, I don't sign on it. Correct. Only, yes.
But they come to your office?
Yes.
And so the Caldwells came to Jerry Tipton's office for these tax returns, right?
Yes.
And the Caldwells also spoke to you about the issues they had with the tax returns, right?
After the fact, yes.
Okay. But these were your employees that prepared them?
Yes.
And you pay your employees as employees to prepare these returns?
Yes.
And you have a responsibility to make sure the employees are properly trained, don't you, sir?
That's what I do, yes, or you try to do. It's just hard, supervising that many people all the time. You don't know what they're doing, but I, try give it a good try to, yes.
Well, I understand that, but it is your responsibility, isn't it, sir? If you're preparing tax returns for the public, that you have competent people working for you?
Yes.
And that they follow the law? Is that not your responsibility as well?
Yes.
Now, if you had reviewed this in 2011, you probably could have found that error on the mileage, couldn't you?
Probably, well, I would say yes, because I would not have the records of the Caldwells, but I would notice there is an awful lot of miles, and there would have to be, more than, visitation miles, yes.
So for 11, 12, and 13, the issue could have been resolved had you reviewed any of the tax returns. Isn't that correct?
Yes.
How can you assure that professional care that's required under your laws, how can you do professional care to people like the Caldwells if you don't review what work is being done in your office?
Well, we just, just so many returns. I've actually made some changes, and we're going to make a whole lot of the changes next year, but there's just no way that I can go over every return that the office files.
But isn't your responsibility to make sure the returns are done correctly if they're coming to your office and your office expertise?
What's supposed to happen, yes.
Well, then, should you not then be maybe having fewer employees or having more people who are CPAs to review it? How can you assure someone like the Caldwells that their tax returns are going to be properly prepared if there's no oversight on that?
Actually can, and we're going to make some errors. I mean, everyone does, and there's going to be some other errors made too. This is not going to be the only error that the office will actually have to make on a tax return.
Well, I'm certain that's true. I mean, we all make mistakes as well, but don't you have a responsibility to attempt to address making sure that there's due professional care done for everybody who comes into your office?
I do that. I just do not review every return.
But there were 3 years of returns with the bad mileage on it, sir.
I understand that, and I didn't mean it to happen. It just happened.
Do you not think you're responsible for that?
Yes, I do.
Well, do you now review every return that's prepared?
No.
Do you have somebody that's licensed that reviews returns for you?
No.
So you still have all these reviews coming into your office, and all these returns coming in, and no oversight. No one person is making sure your employees are doing the right thing.
Correct.
Well, how can you then again assure the public that you're exercising due professional care if you have no oversight?
Well, we just try to do every one of them. You're correct, and we're gonna miss some, like I said.
Who signed the returns for 2011, 12, and 13 for the Caldwells?
I did not know that.
Did you look at the returns after the issue came up?
Yes.
You don't know what employee worked on them?
I just I would say different different employees just for different years. I just don't know that right now. Just today, I did not bring the return with me.
Did you not look at that after the issue came up?
Yes, I did. I just don't remember who did it.
And you don't remember who prepared the returns so that you could discuss with them the errors?
Yes, I did do that. Just as a group, just with all of the employees when we had the training classes.
But was it one employee that signed all 3 years' return, or 3 different employees that signed those returns?
3 different employees. I do not know the answer to that question.
So it's possible then that all your employees were doing the wrong thing concerning mileage?
No, because we have experienced employees and intermediate employees and just beginning employees. Usually, the ones that are the most experienced, do the harder returns.
But who trained these people to do the returns?
I do.
And you didn't train them about the mileage issue?
There's just so many issues when you get into income tax returns. You just cannot cover average. It was mentioned, but probably one other year it was mentioned, and I don't know just on that year if it was mentioned again prior to those years or not.
Isn't mileage one of the big issues that the public doesn't understand, particularly in the Caldwell's case, that they didn't understand that mileage may include going to the hospital, but doesn't include going back and forth to work? Haven't you seen that come up on more than one occasion, that mileage is an issue?
It is an issue, yes.
And it's an issue that could have easily been addressed if someone had been overseeing those returns.
Correct.
But you didn't do that.
Well, I just was not able just to oversee every single return that the office does.
Well, sir, if that's the case, shouldn't your office be smaller? Shouldn't you have the number of people that you can directly supervise? Or shouldn't you hire more people, professionals like yourself, so that this doesn't happen?
Yes, and I have made changes in the future. We're going to make a whole lot of changes next year. I'm going to step back some, and we're going to have a whole lot of changes next year. It's just a huge office that actually got out of hand on me, just to be honest with you.
And you're the only CPA in that office?
No, I am the only one that actually works full time. I have this other girl, who works seasonal for me, who is a CPA, and I had this other CPA this year. So it's just actually 3 of us in the office this year who are CPAs during tax season.
So what have you implemented so that this does not happen again? What process have you implemented for reviewing tax returns so these kind of oversights and mistakes don't happen again?
I don't really have the process for that.
I have nothing further for the moment.
More questions for Mr. Tipton?
I have a couple of questions, but if y'all want to go first. Mr. Simpson, first of all, thank you for coming today. I know it was a long trip, and we appreciate the fact that you're willing to show up today.
Thank you.
You just mentioned that you have 2 other seasonal CPAs that are on staff currently. Was that your testimony?
Yes.
Did you have any other CPAs, whether seasonal or full-time, during the years at issue, which I believe are 12, 13, and 14?
Only, yes, yes. Just only one girl who she's worked for me just for years. Yes,
Okay.
she was there.
But you don't recall if that person was involved either in the preparing or oversight of the Caldwell's returns during
I
this?
don't think so.
Okay. It says on the notice of hearing that your CPA license is in retired status. How long has it been in that status?
Oh, it's not retired.
I may have made a mistake. Let me look back. Your Honor, based on that testimony, there appears to be a discrepancy in the notice of hearing. How do I ask the question to clarify that? Can I ask it of counsel, or do I have to call a witness?
Yes, Ryan, let me just direct you. Thank you, Ms. Roberts. Was that a typographical
It
error?
was not a typographical error. That was the information given to me at the time, but we are now checking to see if that indeed is still true. We're checking right now.
I've got the active license, the certificate here today with me.
I'll tell you what.
But I'm happy to go over some other questions.
Mr. Roberts, why don't you go ahead and ask whatever questions you have, and then once we have a witness over here that can verify this, we'll hear from them. Go ahead.
Thank you, Your Honor. Thank you, Mr. Tipton. I see on the letterhead that was included in one of the exhibits that's been entered that says Jerry Tipton, Certified Public Accountant. Do you hold yourself out as, or do you advertise as a CPA firm or a tax preparer firm?
CPA firm.
Okay. And is that on the basis of the fact that you have an active CPA license?
Yes.
Do you provide any services in your firm other than tax preparing services?
We do compilations, and we do reviews, and just also bookkeeping and some payroll.
How many? Thank you for answering that question. Just was interested. How many tax returns on average, does your firm prepare each year?
This year we've already done over 14,000.
14,000 tax returns a year. How many do you think you did on average in the years that were issued here, 2012, 13, and 14?
Probably 12,000.
But you think on average about 12,000 per year during those 3 years?
Yes.
I think that's all I've got for right now.
I have a couple of questions. You say you do about 14,000 returns. Could you give us any kind of estimate of what your average fee per return is?
I'd say probably $45.
What is your understanding? I mean, you've said you don't review and sign all returns, but do you understand you're required to review and sign them, or who do you permit, or how do you justify letting other people review and sign returns in your office?
Well, it was like I said earlier. I just try to just let the ones that are the most experienced. I've had experienced help. I actually have 2 or 3 girls who's actually worked with me, just for 22 years or more, and and I have a person just on the daughter. You're checking in people, and she assigns based on their return. Who actually just prepares a return, and that's what you're trying to do.
Do the people that review and sign returns have to have any kind of qualifications, either from the IRS or from
they were trying to start something a couple years ago where they would have some continuing education, and they did for 1 year, and we did that. But then I think there was a lawsuit by someone up in the east, and so they don't have that anymore.
Do you review and sign any returns in your office?
Yes, I do several.
How do you make that determination as to which ones you actually review and sign?
Well, actually, all of the partnership. Well, see, most of the partnerships and the corporations, and anyone that has anything that would be hard that I wouldn't want anyone else to do.
Are you aware of any requirements that you organize and operate your firm any differently than you do? I mean, you've indicated you sign returns based on experience. You do training in your office. Do you feel like you have done all the things you need to do for a firm like yours?
I'm going to say the answer to that right now is no, just in the past. But, like I said, we're going to, as the next year, I'm going to have a whole lot of changes made.
And you've indicated you're not sure who in your office actually prepared and signed this return. So I guess I was just interested in that particular person's qualifications and whether their experience and so forth, but you don't know who that is.
No, I'm sorry. I don't know.
Okay. No further questions.
I have some questions, Mr. Tipton. When the returns come in, you said your receptionist is the one that assigns the returns?
Usually, yes.
And what kind of qualifications does your receptionist have to match up?
Well, just on my daughters who it is, she asks them what they have, sees the actual forms, and, just ask them. She has a series of questions. Just ask them, just see what they have.
And once it's been assigned, you have the preparer who prepares that return. Is there anyone else in your office that may look over that return, but prior to it being filed with the IRS or being presented to the
What they do is, if they have one that they're not sure of and they have questions about it, then they will call me or either one of the girls that I have, supervisors, just to look over the return at that point in time if there is any questions or issues about it. I mean, they may start the return and they run into something that they're not sure of, then they will ask us just to come and either help or either finish up the return.
Do they have enough training to recognize issues, or?
I'm going to answer that question in this way. When we have the training classes, the word, trying to come up with a word, I say, please, okay. Every year when we get to things start, I say, okay, there is 3 important things to do. One of those things is to ask questions. Please ask some questions if you run into an issue that you're not able to handle. But sometimes they want to be gun-ho, and they want to try to just actually get into something that they should not be able to, and that does happen. But for the most part, most of them understand, ask a question. Just get help, ask the questions, and we'll help you with it.
Do your signers of the returns, do they have the PTIN numbers?
Yes, the other one has to have the PTIN number. Yes.
Okay. And did you prepare the Caldwell's return prior to 2011, or was 2011 the first year?
I'm not real sure. It was testified earlier that they've actually, I'm going to say probably 5 to 6 years.
Prior to that?
Yes, and I'm not sure.
Okay.
Start maybe back in, 9 or 10 maybe.
Thank you.
Mr. Caldwell, you said everybody had a P10 number in your office. who signs the ERO as the ERO?
You don't have to sign as an ERO. Just whoever does the returns, you'll sign the return.
So that person then is signing the for the electronic signature.
Yes.
On that form.
They can sign both.
But they are actually signing that form.
Yes.
Okay. Thank you.
We got another couple questions. So, Mr. Tipton, in the past, if you have ever become aware of a mistake, like in a filing, do you ever address those mistakes for, like, in planning or for training for the following year?
That's how we usually work it out. Yes, if we have errors and I mean, if we have issues, I always make notes during the year or after the season. You know, when you get just on your letters with errors, then we go over that stuff. You know, more just in detail the next season.
Mr. Tipton, I have just a couple more questions. The complainant here obviously wanted you to pay all of the tax that was due and the penalties and interest. I think that would be very gracious. I mean, you know, if they owed the tax, they owed it anyway. I mean, the return was done wrong, and regarding the interest, they had the use of the money, so paying the interest. I would assume the penalty would certainly be appropriate. To the extent you did something wrong and they incurred an additional cost. But do you believe that this complaint would have been filed had you agreed to pay all of those amounts, or?
I said no. I mean, I always pay the interest. We'll have probably 12 to, every year just a dozen returns probably where we've, made a mistake, turned around withholding tax, left out a W-2 form and that kind of stuff. And it is always, if it is our mistake, I always give them the interest. I'll try my best just to get them out of the penalty, which I can usually do because it wasn't done on purpose. But as far as just on the liability of the taxes, I mean, they owed it anyway, and that's what I tried to tell her. And I offered just to give her back $300 extra, which I didn't have to do that at all, and I offered to do that. She just never did. Like I said originally in the thing, she went on her own to the audit. I would went up there with her. I always go to just the other one's audits that they have. I go uptown with them, sit through the audit with them, and I'd have done that with her just like everyone else. She just didn't want to work with me at all. I mean, she'd call and I'd want to help her. What happened in her case, she just admitted it to me. I mean, they just did not have the money just to pay the tax liability.
Objection to anything that Caldwell said to him on that. They are not here. I can't cross-examine what they may or may not have said in this particular issue.
We've had a lot of hearsay, Ms. Ryan. We've had a lot of discussion, and Mr. Mills was telling us.
Just to mention one the other day that just happened, they're always behind a year just on the letters. So there's a case where a client got a lot of interest on some bonds. Some of the banks, they won't put the interest here, and they may put the interest over here when it is interest just on the savings bonds. They had a lot of savings bonds, and the girl did the return, did not see the interest on the savings bonds, and the interest was over $200, and I wrote them a check. I kind of felt like in this case that the client knew that they had, $20,000 or more just in interest, and they should have mentioned it then, when the return was prepared. But that was one that I did that I kind of hated to do, but I did it because I thought, well, just go ahead and do it. So, we'll have a lot of the interest every year that we pay. We make mistakes on I mean, on that, they'll. It's happened, we're going to make mistakes, but it's usually just a mistakes. Like I said, just to miss a form. I always say, put all the forms out here, enter a form, you turn it over, then enter the next one. Well, some of them, you just can't get everybody to do all the time what you want them to do.
Else from the board for Mr. Tipton? No? Thank you, sir. Did you have any other questions for Ms. Tipton? And then, Ms. Ryan, were you able to clarify the stats of life? Why don't we finish with, I'm sorry.
I much apologize. This information that was given to me from a prior attorney, but it's not correct. His license is not retired and it's not been retired.
Okay.
So that's an error on the notice of hearing.
All right. Okay. Thank you for picking that up, Mr. Roberts. Go ahead, Miss Ryan.
Said earlier that when an issue comes up in your office, you guys have, or you call the office to take a review problems that came up in that tax return. Is that right?
I didn't hear the question. I'm sorry. I didn't understand
When
the
you have
question.
problems that come up with the preparation of tax return that have come up, you call together a meeting of the staff to discuss those issues.
Well, yes. And also, I did not mention this. When you had issues, you had issues during the year, you may have some kind of the issues with the program or something. What I also do is when there's an issue, I always had just on the notice, posted on the bulletin board, and I'll have something, see right there just on the notice 1, 2, 3, 4, 5, where the one knows something has happened, like on the health care insurance this year. Where they actually do know that there is an issue that they need just to know right then about.
So in all the years you've had the office, it was only after Ms. Caldwell's return was audited on the issue of mileage that the issue of mileage came up? All of those tax returns? The only time it's ever come up?
As far as I know, yes. There has not ever been any other audits of my office on mileage.
How many other returns did your office prepare that took the wrong mileage for ministers and persons like the ministers?
I wouldn't have the answer to that question.
Did you notify any of them after this came up that they might have an issue coming up with mileage and that you need to go back over their return?
I don't think that there was any other issues with the ministers, just on mileage.
Okay, is that the only minister and the only mileage in all the 25,000 you've done in a certain period of time? That's it?
I can't say that to be sure.
Okay. You said also earlier, you said you did prepare the returns at one point?
I'm not sure if I did. You probably.
And why did you cease preparing the returns?
Well, there's just other harder returns that I actually needed just to work on.
But don't you think they were relying and depending on you based on your relationship that they would get the correct return done?
I'm sure that they were, yes, and I was reasonably sure that it was done correctly when they were there.
But for 3 years, 3 years of mileage that was incorrect, 3 tax returns? I understand if it's 1, but 3?
Well, I guess if it happened one time and there was nothing done at the time because I did not know that there was an issue then until it got audited.
Are you suggesting, and you don't know who prepared the various returns, is that right?
Correct. I do not know.
So you don't know if it was one person that had this misinformation or 3 different people that had misinformation, do you? You don't know that.
I do not.
So you have no idea how many of your clients had that issue come up and they had it prepared wrong. You have no idea.
No idea. They would have to be audited, before I would know that. Or I would have to, have the reason just to know that.
Why would someone come to a licensed person such as yourself, who's holding himself as a licensed person such as yourself, with an office being overseen by a licensed person such as yourself? Why would a person then come to you instead of going to HR on our block? Because wouldn't they expect to get oversight from someone who's licensed with the state? Shouldn't they have a right to expect that?
I hope so, yes.
But you didn't provide that in this case.
Well, I
You
didn't
did
mean
not
not-
review those returns.
Well, I didn't mean not to. It just happened.
Don't you have a responsibility, sir, to make sure these things don't happen when someone is relying on you as a licensee to give them the advice they need so that doesn't happen?
Like I said, I'm just doing right now, just in the past, doing just on the best that I was able just to do.
Just a moment. I have nothing further, Your Honor.
Thank you, Mr. Tipton. You can take a seat.
I have some other comments I want to make if I
Go
could.
ahead, sir. Go ahead.
Okay. I guess the reason that I am here today, just on the main reason, is that I got to thinking, and I went back just on the balance sheets. I don't guess we have these anymore, do we? We're not sending these out. Like one went out yesterday. Well, I hope I wasn't in until I get this cleared up. It doesn't really matter, I guess. I went back over some of these, well, actually all of them. And I guess I don't know all of the, just on the codes and all that stuff, but it looked like to me that there were a whole lot of other, what's the word I'm trying to come up with, issues, like just on a CPA who did not file his own personal return, who was only fined $500, which to me is a whole lot worse than our office making a mistake on a tax return. And then there's, failure to operate without a license. To me, that's the kind of stuff that's really bad. This is bad too. I understand, and I wish it hadn't happened to the Caldwells. I'd give anything if it hadn't happened. But it was a mistake made. We're going to make other mistakes. I'm not going to sit here today and just say we're not going to make some more mistakes. We're going to make some more mistakes. I'm going to try just to work with a person. If it does happen, yeah. It's actually just to fix it and help them fix it. I would have worked with the Caldwells. Or something mentioned on the office in the home. He actually did have an office in the home. I asked her after it was over. I could have fixed the mileage. Corrected the mileage. There was an office in the home. She didn't want to do it. She didn't want, she did not want to do that. I just think that the fine is just a little high for just a mistake that was made in my office. Let's see, that's all I actually have, I guess, today, guys. Thanks a lot.
Tipton, you can take a seat over here, please, sir. Ms. Ryan, did you have any rebuttal?
I just have closing.
Okay. All right. You want to go ahead and make your closing statement to the board?
There's no question we all make mistakes. All of us do. But that doesn't mean that we're not responsible for those mistakes. It doesn't mean that we're not liable for those mistakes. I, as an attorney, have responsibility. You, as CPAs, have responsibility. If I make a mistake that affects my client, I can be held responsible. That is what happened here today. We have Mr. Tipton, who has a number of employees. I'm not even sure how many. But these employees are preparing tax returns, and there's no oversight for that preparation of tax returns. And yes, he said he's corrected it, but for 3 years, the mileage was incorrectly reported for this particular person. Not 1 year. That would be easy. 3 years. That's not just an oversight. That's a huge mistake. As a certified public accountant with a license with the state of Tennessee, Mr. Tipton has a responsibility to follow the laws and rules of the state of Tennessee and of the AICPA. He has a responsibility to do due care. And responsibility in that due care is representing his clients in a way that does not harm them. The Caldwells had a reasonable expectation based on years' experience with this office and Mr. Tipton himself to think that they were relying on an expert who was going to give them the care they needed and prepare the tax returns the way they needed to be prepared. Now, mileage may be a simple thing to some people, but when it was clear on the documents presented that the Caldwells thought any kind of mileage was acceptable, and apparently so did the person preparing the tax return, that is a big issue. That is something that should not happen. That's not just a mistake. That's not being properly trained. That's not just oversight. That's something even I know as an attorney, and I'm not a CPA, but I'm going to tell you that I have a great respect for the IRS. But I would not make that error when it comes to mileage. I don't even have any training for that. But I know that it's an issue. They knew it was an issue because they prepared it. 1 or 3 people, I don't know how many, did not do that correctly. It resulted in these people having to come before the IRS and pay civil penalties and interest. That was the harm done to the person based on the failure of Mr. Tipton to exercise due professional care over his office. I understand you have 35 employees, maybe you can't oversee them all, but then perhaps you shouldn't have 35 employees. If you are going to offer your skill as Jerry Tipton CPA and his employees, your skill as a licensed person, then you have a responsibility to offer to the public proper care. That's the issue here today. What can you do as a board? I'm not asking for revocation or suspension. You certainly can do that. But I do think that Mr. Tipton needs to understand that it's not just simply a mistake. 1 year, maybe. Maybe you could forgive him for that, but 3 years is a little hard. It is something that he, as a professional, needs to understand is not acceptable. Therefore, I am asking you today to find that he is in violations of the laws concerning due professional care as outlined in your notice of hearing and charges, and that as a result, you issue a civil penalty, which you can issue up to $1,000 per violation. And I'm asking you to issue a civil penalty and to be also requiring him to pay all the court costs in this matter. Those court costs will include and can include, when someone is found to be in violation of the law, the cost for the investigation, the cost for the hearing officer, which is the judge today, the cost for the court reporter. We would not be here, except I understand he has a right to a hearing. But I don't think he understands that it's not just a simple mistake. Thank you.
Tipton, anything else you'd like to say to the board?
Yes, I mean, I'm just on the penalty and on the interest. It was mentioned that, I offered just to do that and you pay that. That was the Caldwell's fault. They were just, they were upset because I would not, pay the tax liability. I offered just to pay the penalty and interest and the extra $300 to them since that happened. They didn't have the money just to pay their taxes, and I hate that. But they are just upset because I would not, pay the tax liability. I offered to help them in any way I could. They would not let me. They want to come down. They want to, file the complaint, which is fine. That's their option. Still, I offered to help them all I could. They would just, I didn't never see any of the documentations. I never didn't know how much the interest was or the penalty was. And I offered to help them all that I could. And also just on the other years that are in question, I'm just not really sure that there was issues in those other years with the mileage, just the 1 year. I'm not real sure what happened in the other 2 years.
Ryan, did you have a proposed order for the board's consideration?
I propose finding of facts and conclusions of law.
That's,
Yes.
that's what I meant. All right, members of the board, if I could have your attention for one moment, let me make a few brief comments to you in the form of a charge, and then I will turn it over to the chair to conduct the deliberations. It is responsibility of the board at this time to make a decision in this case, and that decision will be the final order of this board, and that order will contain findings of fact, conclusions of law, a determination as to what, if any penalty is appropriate in this case, as well as reasons for your decision. The burden of proof in this case is on the department to show by preponderance of the evidence or as the more probable conclusion that the factual allegations contained in the notice, and also it is outlined in the proposed findings, that those factual allegations have been proven and are true. And the burden of proof is also on the department to show by that same preponderance of the evidence that the facts that you find to be true constitute violation of the statute and or rules as is set forth in your in the notice. The proposed findings that Ms. Ryan has handed to you, this is, of course, not to be considered as evidence in this case. This is merely the proposal that has been submitted to you. However, you are free to use this proposal as a guide during the course of your deliberations, and you can accept the language that the facts and that and the conclusions of law as set forth in this order, or based upon the evidence that you find that has been established in this case, or you may completely reject these and come up with your own findings, or accept these with whatever modifications you believe are appropriate based upon the what's been established in this case. As I said earlier today, your decision in this matter must be based only upon the evidence that you heard this morning, that evidence being the testimony of the witnesses as well as the exhibits that came before you. Should you find by your findings of fact and conclusions of law that the respondent, Mr. Jerry Tipton, has violated any or all of the provisions as is, of the statute and or rules as is set forth both in the notice of hearing and in the proposed order, you are authorized by your statute to impose whatever disciplinary action you deem appropriate. In this case, as Ms. Ryan stated, you are authorized by your statute to revoke, suspend, or to otherwise discipline a licensee. You may impose civil penalties, and as well as assess the costs of the proceedings. As I stated to you earlier, I will not participate in the decision that's made on the merits of this case. That decision is for the board alone, but I will be available for any questions that you might have during the course of your deliberations. And if you have no questions of me at this time, I'll turn it over to the chair.
Thank you. Open the floor with our board for discussion. Ask that you look first at the proposed findings of fact, see if we have any questions on any of the 1 through 5 in those. Discussing them.
Mr. Chairman, could we have just a couple of minutes
Sure.
to review
Oh.
this document?
We have a question. Pardon me. We have a question from the member that's on the telephone.
Oh, yes. Forgotten about him. Also, he does not have access to the proposed findings.
Yes.
That was my question. I'm sorry. Can I abstain from the vote since I've heard all the testimony, but I don't have privy to the handouts?
Well, that's a very good point. What I would suggest that you do, members of the board, is especially since this document is not terribly long, when you get to the point of discussing it, then I think that someone should read the facts that you're adopting, so the board member on the phone can agree or disagree. Do you have a copy of the notice of charges? No, he does not.
No.
My understanding, and that was his question, he doesn't have a copy of any of the documents, of course.
I think, actually, Ms. Ryan and members of the board, I appreciate your board members, and I'm sorry, sir, I didn't catch your name.
Stephen Eldridge.
I'm sorry?
Stephen Eldridge.
What's his name?
Stephen Eldridge.
Oh, Mr. Eldridge. I certainly appreciate your taking the time to sit in with us this morning, but I think under the circumstances, you need to just not participate in this decision. You're free to stay and listen, but if you don't have the exhibits and you don't have the notice, then I don't think it would be appropriate for you to participate in the decision. Mr. Chairman, you in agreement with me on that?
Absolutely, sir.
All right. So I'm sorry, Mr. Eldridge, but you're obviously free to stay and listen to the conclusion of the hearing.
Thank you.
All right.
I'm sorry. Can I ask a quick question to that regard? In the event that we had a split, then I think there's 8 people here. What would happen if it was a 4-4?
If it was, you need to have a majority decision on whatever a majority vote on whatever decision you make. So, for example, if there was a motion to take some action, and the vote was 4-4, then that motion would fail, and you would need to come up with some other proposal that would garner a majority.
Thank you.
All right. So, Mr. Chairman.
If everyone had a chance to review the proposed findings of fact and conclusions of law, as a point of clarification, I ask about, so in case anybody else has the question, under the conclusions of law, you have A, and then you come over to 6 and 7. 6 and 7 are actually the sections of the Tennessee Code, and it is not misnumbered. It is correct. So that's why the numbers don't flow.
Mr. Chairman, members of the board, it's just the way that the page is, the type is on the page. If you will look back at the notice of hearing and charges, and look on page 3, where it has causes of action, count number 1. So you see that? Okay, that makes it more clear that we're talking about Tennessee Code Annotated 62-1-111A, paragraph 6 and 7. Okay, so that's what the 6 and 7 reference in the proposed findings that Ms. Ryan filed. Okay, so go ahead.
Thank you. Is there discussion on the proposed findings of fact?
Mr. Chairman, I do. I've got a couple comments, I think. Reading the 5 findings of fact, I personally don't have any issue with adopting those. I have some thoughts about them, but I don't have any issue with adopting those. I would say, though, that given the scrutiny that our board's decisions have been under in the last year and a half, or our actions have taken, I think it would behoove us to add an additional fact, just for the record. And again, this would be deference to the legal piece, our legal counsel, whether or not it's necessary. But the fact would be that the respondent has an active license with the state board, and as such, we actually have the authority to discipline him should we deem that we need to do so. That's not present in the findings of fact. And I'm not entirely sure, I'm not a litigator, so I'm not entirely sure if that's actually a conclusion of law we would need to add, but I think somewhere in whatever it is we adopt, should we adopt something, that needs to be in there for the record.
Are you bringing that up specifically because if he were not a CPA, he could still do a tax return and sign a tax return without coming under our jurisdiction?
That's right. And based on the conversations we've had in previous board meetings about making sure that we don't act outside of our authority as a regulating body, I want to make sure that whatever it is we do, if we do something, that's reflected there for the record.
Let me step in here. I think that's a good point, Mr. Roberts. What my suggestion might be that finding the fact number one would be, and Mr. or Miss Ryan, could you, what is Mr. Tipton's license number? Because what I was going to say was that one way to do that would you
Mr. License number is 11244.
All right, you might just simply say finding the fact number one is that the respondent, Jerry Tipton, currently holds CPA license number, whatever it was, that's active, that's currently active, or something, however you want to phrase it. And that would state on the front end that he is licensed, he has an active license, and then move on to the balance of the facts.
In Your Honor, that would be enough to make it evident that we do have the authority.
Yes.
Then, okay, thank you.
And you might also, Mr. Roberts, and you might also add, if there's any, just to cover all your bases, that he had an active license during the period of time in which the actions that resulted in this that the actions in question in this case I'm not saying it very well. He had an active license at the time that these incidents occurred.
Thank you, Your Honor. Could you repeat, Ms. Ryan, the number again? His license number?
It would be 11124.
11124. Mr. Chairman, can I make a motion?
I'm sorry.
1124.
On Exhibit 1.
I'm sorry, 11244. I apologize. 11244.
Mr. Chairman, may I make a motion to amend our findings of fact, our proposed findings of fact in this order? Is that I would amend my amendment, and I would love for Your Honor to step in if you think I'm doing this the incorrect way, but would be my motion is to renumber the current findings of fact 1 through 5 as 2 through 6, and add as a new number 1 that the respondents holds an active license with this board, number 11244, and that license was active and in good standing during the time period that is covered by the complaints that are alleged in this action. Is that sufficient, Your Honor?
I think that's good.
Thank you.
Do I have a second to that motion?
I'll second the motion.
I'd like to have a roll call vote, please.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Motion carries. Thank you, Mr. Roberts. Very good point. Is there any other discussion on our proposed findings of fact, and it's been presented to you?
I have a couple of questions.
Okay.
On the proposed findings of fact, I noticed, and maybe y'all can clarify, it references a single tax return. It doesn't reference other years. It says the client's federal income tax return.
Ms. Weatherby, at this point, we need to keep the discussion amongst the board members, and if there was not evidence in the record to support something in the facts, then you need to construct the facts in a way to conform to whatever evidence was presented to you.
Okay. Okay. I have a couple of other things, and if I'm wrong about asking these, just let me know. But um, in all these documents, and I may have overlooked it, did any of you see anything from the IRS where we know that they actually were fined and paid penalty? And I didn't see anything.
There was nothing that I saw in the record that from the Internal Revenue Service. However, both the respondent and the claimant both mentioned the fact that there was no dispute between the two that they were assessed. We just don't know how much was assessed. And replying to your other question, there was only evidence presented for the 1 year on what the mileage was, although everyone agreed that there were 3 years worth of returns. So that would clarify, I think, that question.
Was there, because I don't believe that Mr. Tidwell, there was, there was some questions to whether they were actually audited for 2011 and 2012. We have not seen evidence of a penalty or assessment for those 2 years. Or, that's, to my knowledge, that was not provided to us. So I question, I don't know whether we even want to state that as a finding of fact. It says they were audited for 2011, 2012, and 2013, resulting in penalties and interest, but we've not, to my knowledge, that was not acknowledged about 2011 and 2012.
Mr. Tipton's letter that we were D1 on Exhibit 3, he also acknowledges that at least 12 and 13 in his, and so we know there was more than 1 year audited by both accounts, although we have not seen any documents accordingly.
That still eliminates 11, though. Are we supposed to, we're supposed to make sure our findings of fact are findings of fact?
That would be correct. I'm just discussing with you.
I think it's unfortunate that the Caldwells did not appear and that we have no records from the IRS. That makes it very difficult to come up with a conclusion.
Procedural question. Is it appropriate to ask you that question? On the I forget which exhibit number it was, but I believe it was the case summary or case file from Mr. Mills, the investigator. It was entered as an exhibit. The case history beginning on page A2, which is actually the fourth paper page of that document for the board members. Mr. Mills states in his report that the complainants alleged that after receiving an IRS notice and their subsequent audit of their tax returns for 2011, 12, and 13, part of their allowance for mileage taken for business was disallowed. From a procedural standpoint, because this is, I think, really the only evidence that we have, is it sufficient for us on a legal grounds to rely upon this statement as evidence that there was an audit and subsequent penalties for all 3 years, or would there need to be more evidence of that for us to make that finding a fact?
The only response I can give you, Mr. Roberts, is that is your decision to make, whether or not you feel like that's sufficient evidence to make the determination that that's true.
Thank you.
Further discussion?
Excuse me. I'm sorry, Mr. Chairman. Go ahead.
The chair would entertain a motion to drop the 11 from the finding of fact, in that we have both sides agreeing in written documentation that there were problems with the mileage in 12 and 13, I believe.
I would be okay with that, but I didn't see about 12. Could you just point that to me so I may have just missed it.
I noticed that in Mr. Tipton's letter that it said, I thought it was only 12 and 13. So I don't know that we could
And
make that assumption, that further assumption. I think that
I'm not sure. He said, I actually thought the audit only covered 2012 and 2013. And that does not say that there was that there was a penalty or interest assessed on 2012.
I don't think we have any proof that there was. I don't think in any of the documents Mr. Tipton has ever been made aware, at least in what we have, of how much was assessed, and
or if there was an assessment,
or if there even was. I mean, it's
and I will say it's common for the IRS to, when you're audited, to try and make it a 3-year audit. But unless you take the evidence in, there is not an audit. They would have to actually re-request those other years. So they will standard say we're auditing 3 years, but you are only required to bring in the year that they're specifically auditing. So without evidence that that actually occurred, I don't believe we can state 2011 and 2012.
I think that's a great point, but just for safety, I want to make sure that we're not considering anything outside of what was been presented. So I would almost just focus on, we don't have any proof of all 3 years actually were audited, or that issues were found in those 3 years.
Right.
And that would be the basis for me to agree to a motion, to the extent someone can come up with one that actually has been proven in evidence, other than allegations.
Someone would like to make a motion to that effect, to limit it to, I assume the 13 years what we're referring to here, and that's the only true evidence we have in what we were looking at. I don't think it weakens what we're looking at.
Mr. Chair, I don't even see that we have anything that proves that there was an audit. I mean, I don't have anything in my papers here that prove the IRS audited and that there was an assessment of any kind.
Be appropriate to amend the new number 5, finding of fact, to simply say the Caldwells allege that their tax returns for 2012, 13, and 14 were examined and penalties and interest were assessed, because it is included in their complaint. I'm looking at B2 under this summary case thing, where they clearly say they were audited for those years, and that's their allegation. So can we just change the wording there to say that? I mean, that is a finding of fact. They did allege it.
I would just offer as a complimentary, I think if we're going to do that, I think we need to be fair, and I think we also need to add that the respondent thought that it only applied to 2012 and 2013 as either another finding of fact or part of the same finding of fact, so that we're fair to both parties' comments or allegations.
I'm okay with that, and I would ask you, maybe Gabe, being an attorney, to
let's hope the contract lawyer in me doesn't come out and we have a 5-page sentence. So I guess it would be new number. Give me just a second to think through this piece. New number 5. My motion to the board would be to rewrite new number 5 as the Caldwells allege they were audited for their 2011, 2012, and 2013 returns, resulting in penalties and interest assessed to the Caldwells. And then I get, Your Honor, could we, I'm sorry.
That should be a new number 4, right?
New number 5.
We renumbered.
Oh, okay. Sorry.
In the middle of my motion, I'm sorry. Your Honor, can I ask a question? Did each finding of fact, can it only be one sentence, or can there be 2 sentences? Okay.
As many as you want.
All right. So restating my motion, new number 5 would be, I propose it be the Caldwells allege they were audited for their 2011, 2012, and 2013 returns, resulting in penalties and interest assessed to the Caldwells. Mr. Tipton thought that the Caldwells were only audited for 2012 and 2013. Perhaps inartful, but that's my motion.
We have an amended motion. Do I have a second?
A second.
Roll call vote, please.
Booker Davis,
Aye.
Larry Elmore,
Aye.
Gay Moon,
Aye.
Gabe Roberts,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart,
Aye.
Judy Weatherby.
Aye.
Mr. Chairman, I have one more comment, but if you give me just a second to try to find
Sure.
the basis for that comment. So I've actually got a question to the board. So new number 6, I'm not entirely sure is supported by the evidence. It says that Mr. Mills, the sentence during the middle of it says, investigator Don Mills found that there was direct evidence that mistakes were made on, quote, the return. So my question for the board members is that, there's an allegation by the complainants. There was 3 returns at issue. The respondent says there's only 2. And our investigator says there was only mistakes. There's direct evidence of a mistake on 1 return, but doesn't identify what return that is. I don't see anything in the investigator's report that actually indicates what the mistake was and which return it was on. Has anybody else seen that in the investigator's report?
I believe that Investigator Mills testified that he did not actually see the income tax return. So I think that the new number 5 needs to be eliminated.
Your Honor, can we have the court reporter review Mr. Mills' testimony to see exactly what he did testify to regarding that?
Yeah, but it's probably going to take a little bit.
I think it's important, board members, for her to do that, but that's not my decision because I want to make sure this is right and we didn't miss something either in testimony or that's already on the written record.
And one other thing I would like, while you're reviewing that, is on new number 4. It says the respondent admitted that he did not sign or review any of the Caldwell's tax returns prior to the returns being submitted to the IRS. He, if I'm not mistaken, in his testimony said he was not sure if he had in prior years signed any of the tax returns himself.
But we're only talking about at that time the 11, 12, and 13 in this finding of fact, not previously.
So that doesn't refer. That's not referring. Okay, that's good.
Just point of clarification. I think we're okay on that one personally. But
well, it
it
isn't clear here. It says the respondent admitted that he did not sign or review any of the Caldwell's tax returns, and that comes before we mention dates.
It can be clarified with the 3-year returns that we've got, I presume.
Let me interrupt for a moment, because as we all talk, she's having to take it down. Let me make a suggestion to you. Let's go into recess and give her time to find Mr. Mills' testimony. All right, and then she can read it back. Can you?
The particular portion regarding any mistake or evidence he found of a mistake, and if so, what year it was in, or what year's return it was in.
I thought it was whether he actually reviewed any tax returns.
No, we're talking about two different
things.
Two different things.
You know what I think
of the evidence and the returns.
Your Honor, I don't. Is it even appropriate to ask that question? Because I'm not trying to draw it out. I just want to make. I don't see anything on the record.
I think that's fine. I think that's very appropriate. This is what I'm going to suggest we do. Let's take a short recess, and while she's trying to find this, I would suggest that the board members take a few minutes and think hard and review. I'm not being at all critical. I think y'all are doing a very good job, but think hard and look at the fact what you think has been established in this case. And so we can use this time constructively while she's trying to find that. When we go back on the record, then I'm not saying you can't take a restroom break if you want to. I'm just saying that some of the other issues that have been raised here, so we can lock this down. All right. So.
Sure. See if Mr. Mills ever testified as to what the direct evidence was, if any, about a mistake made on a particular year's tax return.
In recess.
Reporter says that she thinks she's found the portion of Mr. Mills' testimony that Mr. Roberts was asking about. So can you read that to us, please?
Question, do you know how many years this mistake went on? Answer, I do not. Question, do you know if it was more than 1 year of tax returns? Answer, I do not know that.
What you need to know?
It is for me. I don't know if any other board members had any other questions.
Well, I wasn't entirely comfortable with the number 5. Was somebody else mentioning to just delete it altogether?
Number 6.
Yeah, the new number 6. Yeah, is the one I'm talking about.
I understand your concern about that, Gabe, but I wondered if we could 6 to just say during an investigation by Tennessee State Board of Accountancy, Investigator Don Mills
Could you speak up, please, sir? I can hear you.
new number 6, and might need to move the wording around a bit, but just say Investigator Don Mills testified that during an investigation by the Tennessee State Board of Accountancy that there was direct evidence that mistakes, and then the remainder of the wording is okay, but I think he did testify, by his report that he found direct evidence, but he didn't present any direct evidence.
May I ask that we clarify one other thing? And I could be wrong, but I believe Investigator Mills, when we asked him if he viewed the returns, he indicated he had not directly seen the returns. I didn't know if, I'm sorry. I wondered if you have that area up, if you could read us what he said there.
Miss Weatherby, I always hesitate to get involved in any findings of fact from the board, but to save time, and if anybody wants to disagree with my memory, but I do specifically recall him saying that he did not see any tax returns.
I agree.
I would agree with you.
So on that, then, Casey, I get that we're trying to conform the finding of fact to what Mr. Mills testified to, but I don't know that I feel comfortable saying that as a fact, evidence was presented that direct evidence of a mistake is something that we can be sure of as a fact.
I'm sorry to interrupt, but let me point this out as well. That what you all are doing, you need to determine what you think is true. The mere fact, and I'm not suggesting that Mr. Mills said anything untruthful, but the mere fact that somebody testifies to something that's not a finding of the fact that he testified really is irrelevant. It's what do you think is true? So if you make a finding of fact that Mr. Mills testified to such and such, that may be true, but it's not getting you anywhere. Whatever it is that he is testifying about is what you need to make a decision on as to whether or not it's true or not. You see the distinction I'm making?
We have exhibit number 3 here, the last page of it, that's presented, the list that was presented to us of the findings that both the complainant and the respondent have agreed to. There were mistakes made on that 13 tax return. So I think at issue, from at least my viewpoint, is that we have said we really don't have any evidence on 11 and 12, but both sides have said that there was a problem with the mileage taken as presented in, and I'm not sure it's the last page of Exhibit 3, that everybody's agreed to there were pretty significant errors made on.
What, I don't know what, so there's not a date on this page. I mean, I see that, but there's not a date on it. And it doesn't, I don't see anywhere where it says which tax return it's related to.
And I'd also have to point out that we know that commuting is not allowed. However, weekly services could be from an allowed place. So because we don't have the IRS findings to say this was not allowed, I don't feel comfortable saying that even this is a mistake. I really would want to have the information showing that this was what they found to be a mistake, because this may not. Again, it doesn't say commuting.
I agree with that, and based on the instructions from the judge, I mean, and I understand what he said. I think we need to strike new number 6 entirely.
I agree. Yeah. Is that a motion?
I'll make that a motion that we strike new number 6 under proposed findings of fact in its entirety.
I second that motion.
We have a motion and a second on the floor. Is there any discussion? Here now, may we have a roll call vote, please?
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Mr. Chairman, can I ask a question based on that?
Yes, excuse me.
Your Honor, given the fact that new number 6 has been deleted, is there anything we could do now? I mean, the facts that are stated are facts that are stated, but there's no, as I see it, my question is, do we continue to look at conclusions of law, or is there no longer a basis to move forward?
Well, I mean, you may add you may add any facts that you wish based upon what you think of the evidence that's been established. There may be facts that you think are appropriate here that Ms. Ryan did not put in her proposed order. Now, I'm not suggesting that there are, but like I said, you're not bound by this in any way.
Roberts, I would state that, in our revised number 1 or 2, actually, I guess it is now, that we've stated, and this whole thing is about due professional care and a failure to have due professional care. And what it was related to, whether it was in making a mistake on a tax return, the due professional care by not supervising anybody and running 14,000 tax returns out of the office without looking at them is what we're looking at here. Is he operating and protecting the public? And I think we do have a finding, in my opinion. So.
Okay, and I don't have an opinion either way. I just want to make sure from a legal standpoint we can move forward. Okay, all right.
Mr. Royston, what I would suggest, sir, is that if that's the way you wish to go, that you make a specific finding of fact along the language, following the language that you were just saying to Mr. Roberts.
You're saying modified number 2 for clarification. Our new number 2. Failed to exercise, or maybe it's new. It's 2 number 2.
Well, I think what I heard you say, Mr. Royston, was that Mr. Tipton admitted to not reviewing all of the tax returns that were submitted from his office, or words to that effect. I mean, isn't that what I heard you say?
Would you recommend that we can just take that, just rewrite that particular one then for
or add a new one?
Okay.
So right now we have number 4. Respondent admitted that he did not sign or review any of the Caldwell's tax returns. And again, I don't believe that that's a finding of fact, because we don't know that he didn't review any of them. Perhaps
I would say he said he did not review.
The fact that he admitted
that was in testimony that he did not review any of those specific returns.
Those specifics, but
Right.
But that doesn't say, that statement says that he did not sign or review any of the Caldwell's tax returns. So it doesn't reference
the years in question.
The years in question. It doesn't say that he didn't. We could say respondent admitted that he did not sign or review the 2013 tax return, but he made the statement that he had reviewed prior to 2011, and that he may have, yeah. And I guess
and then the simple thing would be any of the returns in question would be the simple way to fix that line.
I'd make a motion that we revise the new number 4 to say any of the Caldwell tax returns in question.
Second that.
Have a motion and a second. Any discussion? Roll call vote, please.
Janet Booker Davis.
Aye.
Larry Elmore. Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Back to the original. Does someone have a motion so that I'm not making the motion to clarify our finding of fact on following due professional care and what it entailed?
So I got a question for you on that, though. I guess I'm not entirely clear on what you're trying to get at. It seems to me like what Ms. Spiceland just offered for new number 4 gets to where you want to be, to the extent of making the determination that lack of oversight equals not due care. I think that my opinion would be that would be a conclusion of law, but I would defer to the judge on that.
Right on that.
I'm not going to make the motion because I don't know that we need to, but if you think we do, I'm happy.
My discussion was the fact that we still have the original charge of lack of due professional care is what it was all about to start with.
Right. So my understanding, I think, and again, I'm open to the boards and the judge if I'm wrong on this, my understanding is we're trying to just get the facts that have been established that we believe now. And then I think the decision as to whether those facts constituted not exercising due professional care is a conclusion of law that we need to address after we finish with the findings of fact.
Okay.
But do we have to make a motion to accept now the findings of fact that
Yes.
I would make a motion that we accept the findings of fact as stipulated now.
Second.
I have a motion and a second. Does everybody understand what the restated findings of fact are? Hearing no questions, let's have a roll call vote, please.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
point, then we need to move into the findings of conclusions of law as presented to you. We have 3 counts. Each one of you's had a chance to look at them. I'd like to take them one at a time and see if there's any revisions to those. On count 1,
Mr. Chairman, point of order. Are you asking us if we have disagreements with them, or are you asking us for general comments?
I'm asking for general comments and disagreements. If we think that number 1, or if we need to handle them as all 3, I think taking them as one at a time, that they either are still in play or not.
I got you. I would agree with that generally, how we go. My opinion from reading 1 and 2 is that we might need to talk about them together because they intertwine, because I think count 1 refers to the substance of count 2. But that's your decision.
I would agree with you.
Okay. So I have a comment, if you don't mind. So I mean, obviously, I think what we have here is a serious issue because for the last, I think, year and a half, maybe longer, this board has been dealing with what happens to people who prepare tax returns. And we've kind of been all over the map until we got some really good legal guidance a while back. And so now what we understand is that to the extent that we're going to try to regulate tax preparers' activity, it relies on whether or not they have a license with us. And so this issue, I think, is maybe a matter of first impression to us, where we actually are regulating someone based on tax preparation work because they have a license with us. And so as we understand it, I think as a board, I'm speaking for all of us, so tell me if you disagree, that we're totally obviously within the realms of our sandbox here about being a government regulator. So I think it obviously is a serious issue. My opinion, based on reviewing what we have here, is that we're being asked, and I think it's not really an opinion, we're being asked to find out if was there a violation of the due care standard for performing professional services. And we don't, at least it hasn't been presented to us that our rules or any other governing or interpretive or authoritative body define what due care means. So I think we are inherently trying to piece together what at least a portion of what due care means by what we're being asked to do right now. And so if that's the case, then I think what we're trying to figure out is, do 3 mistakes over 3 years on tax returns, the fact that those occurred allegedly, right? Does that, if they occurred, is that tantamount to a violation of the due care standard in performing professional services? So based on testimony, Mr. Tipton said that he believed that on average his firm did 12,000 tax returns during 2012, 13, and 14. And regardless of how many errors or mistakes were made, the only thing before us are 3 of those, right? There's 3 errors that we're looking at. So by doing some simple math, that means that that's a 0.008% error rate. In other words, that's a 99.992% correction rate. And so I am of the opinion that there's not been proven that the due care standard has been violated, because I believe if we were going to say that a 0.008% error rate was a violation of due care, that I think we are telling our profession that we are not holding them to a standard of due care, but a standard of perfection. And I can tell you that as an attorney, if I was right 99.992% of the time, I'd take that to the bank. And that's my opinion. So I don't believe that a violation of the law occurred. I don't believe as a result of that we should find count 1 or 2. And then as a result of 1 and 2 not being there or proven, I don't believe that we can give the relief requested, which is the relief / count 3. I don't believe that we should charge any fee, any fines, any hearing costs, any investigatory costs. I think we should dismiss this with prejudice, if that's the right term. And I think we should thank Mr. Tipton for being here, and I think we should move on.
And I would not have said it nearly as eloquently, but I'm in a complete agreement.
I'm in agreement, and I'm in a total agreement too, Gabe. Just one thing I would add to that, I do know that we all make mistakes. Our firm makes mistakes, and when we do, we correct them. And I think Mr. Tipton has testified that he offered to do more than what I would consider reasonable in correcting this situation. I mean, you cannot hold him liable for the taxes due. Again, I think offering to pay the interest and penalty is more than enough, and he has already said he offered to do that. So I totally agree with you, and would suggest that we need to get on with this and get to.
Further comments?
I have one comment. We all make mistakes, but systemically, is there anything that we can do that would require some education about managing the practice to avoid or having procedures in place with a better review of those returns? Because that is part of our job in protecting the public.
Yeah, I would agree. I didn't take this hearing to be that we were trying to determine that he made a mistake, but was he managing the practice properly? So I don't know that saying that this error rate is so small changes the fact that he's not exercising due care in trying to catch those errors.
Well, I think
even though there's not been many caught, I mean, I just didn't. Maybe I'm looking at this differently than others, but I thought exercising due care was the question.
And I hope that, and I'm happy to restate any of my opinions or reasoning, and that was my focus. I mean, the point is we can only rely upon the evidence in front of us, and the only thing we have are 3 mistakes over a 3-year period, during which time his firm submitted 36,000 tax returns on average. Yep. And as a result of that, the question, what I was trying to say is that if you're going to make a decision that error rate equals a failure to oversee his practice such that he didn't abide by or exercise professional due care in performing services, I won't go there, because I think that's holding him to a standard of perfection.
I think if you're counting on the error rate, I agree. But if you're counting on his testimony, he's saying, I'm not reviewing these returns.
Well, I guess the question is that, do you believe that there's some nefarious activity or some issue going on that's not reflected in the evidence of the fact that there have been 3 errors that resulted in a complaint? I mean, I don't know. That's not for me to decide.
But the standard doesn't say you don't have to do the exercise of due care if there's not mistakes happening. It says you have to do it, period.
But does the standard of due care does it say what that means? I mean, does it require 100% review of all the details of every deduction, business expense, et cetera, on every tax return your firm does? But to me, he said that he was very clear that he offers training to the people that prepare his tax returns, and that when errors are discovered or mistakes are made, he comes back the following year and retrains his staff. To me, that is, and for lack of any guidance on what due care means, that sure fits within the sandbox, in my opinion, of what due care means. That's my opinion, though.
Agree. That is I don't see how we could say what tax preparers are required to do in our definition of due diligence. And when the point brought up of what we actually do in terms of penalties and how we assess it, he said he looks at the more difficult tax returns himself. Unless we're willing to make law to say what a tax preparer that is a CPA has to do, then I don't believe we can say he didn't do due diligence.
During the discussion and the questions that have come up, it appears there's enough question that at least, or feeling that that there's been a violation of due care. My personal feeling is that it's if that's the only error rate that we know about, that it's a sloppy practice, and we hold ourselves to a higher standard. That being said, the answer to that, with the feeling I think coming across the board here, is that we can find him not guilty on this, but with a letter of instruction on how due care should be followed.
Could make a request,
Absolutely,
a
it's a
friendly amendment
discussion.
to your. So, would you mind if you're going to make that motion to make those as two separate motions? One that we dismiss this with prejudice is what I would say, but I would defer to legal counsel on what the right meaning that it can't be rebrought, and two that we would then issue a letter or whatever you're asking about. If we can do that.
Mr. Roberts, what I would suggest on that your motion would be that your conclusions of law are that the findings of fact do not support a violation of any of the provisions set forth in the notice of charges.
That would be the motion I would like
and
to
then
make.
Right, I mean that would take care and therefore this matter should be dismissed.
Okay.
Now that would take care of the actual allegations and that would be with prejudice. Now if you have Mr. Royston had suggested something else, and that would be, again, I think you're right, that'd be number two.
Okay.
The first thing you need to do is address the allegations of law.
Okay, so I would, Mr. Chair, if you don't mind, I'll make a motion. I make a motion to the board that we find, as a conclusion of law, that the findings of fact that this board has already made and adopted do not constitute a violation of our law or rules relating to the standard of due care, and as a result, this case should be dismissed.
I'll second that motion.
We have a motion and a second on the floor. May I have a roll call vote, or was there any discussion? Okay, roll call vote, please.
Jana Booker Davis.
Aye.
Larry Elmore. Oh, I'm sorry. Gabe Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Motion carries. Did you follow up with the other two motions?
I mean, it was your
That's
motion.
fine. I'm happy with whatever. No, I was just discussing.
I'm talking about the letter piece. If you would.
I'd prefer not to make motions as the chair. Is why I was deferring to you, since you make it
Well,
all
I personally don't think I wouldn't be in favor of that motion, so I don't want to make the motion.
I'd like to make that motion because that's one of the reasons I went aye on the first motion. So,
Yeah.
so I think the motion would be that we issue a letter. I think what we meant was suggesting that he reevaluate his standards in his office about due professional care. Now,
And the review process.
now I don't know if I had.
You make a motion?
Yes, my motion is
Okay.
that we would
I
do
second.
that.
I second that motion.
That would be a letter of instruction. Is that our current? Okay. You know, and that would refer to, for point of discussion, refer to the, since we have a second on the floor, the standards and what we would expect to see in those standards. Okay. We have further discussion on the motion.
Well, I'm going to vote nay, but I want to explain why. I think that this is a serious issue, and I absolutely agree. And I defer to you as practitioners as to what the appropriate practice management is. But based on testimony and the evidence that was presented today, it seems to, I don't know what else we could ask him to do other than to identify errors that his staff or he makes during the year, try to make the individuals whole, and then the next year retrain people to try to avoid those same errors. So as a result of that, I'm going to vote nay on this letter because I don't know what we would actually be instructing him to do that he isn't already doing.
I guess I would respond to that in the discussion phase, in that he also testified that he did not really have a look over the shoulder review process in place in his office. He was going to establish those, but basically they put the returns out without proper review.
So my only question is, what is the standard for other tax, understanding that this is different because he holds a license, what is the standard for other tax preparing firms that file thousands of
I'm looking at CPA firms and the standards that we're held to with our license.
I'm just looking at the substance of what this CPA firm did, which is not a test function, and it's a tax preparation piece.
I would contend the IRS holds us above with our CPA certificate in saying that we don't that we're exempt from all the other standards and hoops that people have to jump through, and that I'm going to uphold that credential and not use it as a puppy mill for tax returns.
And I think one example of one thing I'd like to see reevaluated is not only review those returns that are more complex, but also review those returns that are being prepared by a less experienced preparer.
But that doesn't occur in general practice. I mean, outside
I don't
of
know
a
what
CPA.
practice you belong in, but it doesn't.
Well, I'm sorry. I mean, outside of a CPA.
But we're not discussing people outside of a CPA firm.
But
he's operating this operation under the banner of a certified public accountant. So that is a standard that we're trying to uphold and protect the public. If they come into a CPA's office, they're expecting a better standard, or they would have gone to mom and pop's tax service.
I understand that they're expecting a better practice.
Well, then we want to be sure they get it.
But I'm not sure how we're defining it. As Mr. Roberts pointed out, how do we say what is enough? He's commented that he reviews as best he can. Are we going to say, well, you should only be able to do 500 or
review process?
But again,
we all can't review all of our returns. Nobody expects you to. But somebody looks at them.
Based on what he's testified today, in my opinion, there's not enough review. That's all we can go on is what he said.
Then is our letter going to say, based on your testimony today, you're not doing a sufficient oversight?
Based on your testimony in front of our board, we feel you should reevaluate your review process and make corrections as needed.
I'd like to be clear for the record too that I have the utmost respect for the CPA profession. It's been good to me in the 2 years that I was in that, and I certainly understand that what the point Mr. Elmore and Mr. Royster are making, and I have no desire to try to minimize that. The only reason why I'm voting for nay is because of the lack of specificity in what we want to include in the letter, and I can't in good conscience vote for that. Now, to miss what Ms. Spiceland said, if y'all want to get more specific as to how you want to do it, that's great. But I guess my experience, I've never prepared a tax return other than my own, and I have a very easy tax return to prepare. But my experience as an auditor is that when you provide an attest function and an attest engagement, and you issue a clean audit opinion, I'm not saying that I've viewed 100% of every single thing that happened. You do it on a statistical sampling basis, and I understand that's probably not a very good analogy. But in the lack of specificity, if I were in Mr. Tipton's place and I received the letter, I think I would feel as though I'm required to look over all 14,000 tax returns that I do, and I'm not sure that's the standard. So the reason why I anticipate voting nay, absent an amendment to the motion, is that why are we sending a general letter that says do something, but we can't even tell him what it is he needs to do?
What we can go on is his testimony, and we don't know what he's doing. We could be here next week at this time going over all of his review procedures, but I think we have to point out that based on what we heard today, it's not enough.
All I'm saying is the regulating agency, I think it's incumbent upon us not to be vague in our instruction, and absent something more or less ambiguous, I'm going to have to vote nay.
To me, vague is better than nothing.
Would it be appropriate to call for the question on this?
Is there a second to calling on the question?
I'm not sure I understand what
that means. Calling for the vote. That means to cut off debate.
Let's call for a vote. I second.
Second. All in favor of the motion? Roll call.
That was close.
Janet Booker Davis. Larry Elmore.
Vote on the call.
Just to call for the vote.
Call.
Kay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Okay, the call for the question's been passed. Motion on the floor is to issue a letter of instruction to Mr. Tipton. I think we've all discussed that. May I have a roll call vote on it, please?
If I'm to prepare this letter of instruction, I just want to be sure what's in this letter of instruction. what I understood was that based on testimony today, it's to go over the review process.
Evaluate your current review process and make corrections as needed. And I think if we do that, we're leaving it up to Mr. Tipton to determine whether he feels like it's appropriate to change something. But all we're conveying to him is our opinion that based on what we heard today, it's not enough, or it may not be enough. We'd have to get his internal control manual documentation to determine what changes we would need.
I'm sorry, are we in discussion or are we about to vote? I don't know.
We're discussing the motion. She had asked for clarification.
Okay. All right.
Roll call vote.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
AC Stewart.
Aye.
Judy Weatherby.
Aye.
Guys have it.
Mr. Chairman, all you need left to do is to make a statement is for the reasons for your decision, policy reason for your decision, sir, or the board's decision.
Tennessee State Board of Accountancy is charged with protecting the public by enforcing the standards of practice for licensee. And in this case, we believe that there's room for improvement in this practice, and therefore have found the defendant or the respondent not guilty of the charges, but have issued a letter of instruction to him for the improvement of his practice in the future.
Okay. If there's nothing further, we'll stand adjourned. Thank you.
Thank you.
Thank you, Mr. Tipton. Good luck.
It'll definitely happen. Thank y'all.
Thank you. And this is the way we hope it works. It's never anything but an education unless there's absolute violations. And we appreciate you taking the time and understanding where we're coming from. And you can see there's a varying, that's why the board's made up of public members, attorney members, and all, so that we're giving you full benefit. Some of us are passionate because we have a niche that we are in, and but neither one of us ever want to see each other on these terms. And gosh, I don't know how you do what you do, because I just went through the worst tax season I've ever been. You don't get much sleep. Thank you, sir.
Thank you.
Yeah. Are we?
Can we, us for lunch?
Yeah, that'd be fine, and we take a short.
20 minutes.
I think. Can everybody?
15.
I'm happy with whatever you take.
How about we eat while we work?
Fine with that.
Adjourn our board meeting today with. I guess we're down to the board committee reports.
Actually, Mr. Chairman, we have the reinstatement of revoked license Tracy Wright that I think we need to handle.
Okay, thank you. Would you bring us up to date, please, on the absence of Ms. Wright, please?
I sure will. And before we continue, can I confirm that Steven's on the phone?
I'm here.
Okay, great. Okay, on Tracy Wright, if you'll recall from our last meeting, her CPA license and firm permit were automatically revoked by the board in March of 2008 after Ms. Wright failed to fulfill the payment obligation for a civil penalty issued in August of 2007 consent order. Since the revocation of her license, Ms. Wright has been disciplined twice by this board for unlicensed activity, 2011 and 2014. As a result of one of those disciplinary actions, Ms. Wright agreed that when she applies for reinstatement of her CPA license or permit, she must appear before the board in person at a future meeting as a condition of her reapplication. Ms. Wright submitted a completed application for reinstatement on August 10th, 2015, including the appropriate CPE. At the last meeting, she was supposed to appear in support of that application and was unable to attend. This board gave her the opportunity to attend this meeting. We did provide written notification of the date and time on 2 separate occasions of this meeting. We received an email from her at 11:14 today indicating that she was very sorry and had it on her calendar for 2 weeks from today rather than today, and that she would not be here.
Thank you. Legal.
Yes, sir.
Would you advise us as the proper steps to take? I assume that all we need to do is we had put the review of her application on hold pending her showing up, and all we need to do is deny that application at this point.
That's correct, sir. One of the conditions, which is unique to her situation because of a consent order she had previously executed, was that she appear before the board if she ever sought to seek reinstatement. I believe at the last meeting, Mr. Roberts wanted to afford her the opportunity to come here to speak. We, as Ms. Garvin indicated, provided her ample notice and opportunity. And at this moment, because that's one of the conditions of her reinstatement, we could not reinstate it, period. That does not mean that you could not deny it.
She has filed the application, so we need to act on that application, and if she has failed to appear, then it would be a denial based on her. I would accept a motion.
Mr. Chairman, I would be honored to be the one to make the motion that this board would deny that application. It's very disappointing to me that when we did the balance of harm analysis last time, we thought that it wouldn't harm anyone and perhaps be in Ms. Wright's best interest to give her an additional 3 months to show up. She failed to do that for whatever reason, and so I would make the motion, since I'm the one that made the motion to extend this, that this board formally deny that application, her application for reinstatement.
Have a motion on the floor, and we have a second, Ms. Weatherby. May we have any discussion? Ms. Conant, would you do a roll call vote, please?
Yes, sir. Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
I'll be abstaining.
Aye.
Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Motion carries. Okay, but we have the executive director's report then, Ms. Garvin.
Okay, on your iPads, this is listed as director's report.
It says acting too, but they're not any longer.
Yeah, Dave.
She's the real McCoy.
I'm the real McCoy. Okay, I'll just go down through, hopefully quickly, the items that I've listed on this report. If you have any questions, just let me know. The only thing I believe we'll need a vote on is future meeting dates. The last one on that list of July 16th, 2017 has not been approved yet, but those are our future meeting dates. TSCPA activities, I did attend the TSCPA Board of Directors meeting on April 29th to update them on some issues this board was facing at today's meeting and throughout the year. I also attended the TSCPA Chattanooga chapter meeting on February 18th and gave a brief presentation as to the board's activities recently. With regards to NASBA's meetings and activities, I attended the Executive Director and Legal Conference in March, as well as our attorney, Ben Glover. Topics that were covered during that time was the CPE tracking system. We use that. It's not required of licensees who are audited in our office, but it is an option if they would like to submit their documents via this tracker, they can. NASBA is making some significant improvements to that tracker, which we expect to be released in the coming months, and we will be one of 8 states to see those benefits soon. So hopefully you'll see some improvements there if you use it. Some of the other items covered were the CGMA designation, which we talked a little bit about yesterday, and use of titles in general. The next version of the CPA exam, challenges with peer review, some enforcement efforts, engaging board members in current legal topics and legislative items from around the country. I believe you all have received probably multiple emails on committees that that NASB is asking for volunteers on. I had one board member, I believe, share with me that they had volunteered for one. If anybody still wants to volunteer, I believe that's still open, and you can let me know if you have any questions about that. Future NASBA meetings, we do have the Eastern Regional meeting in June, and I believe Gay Moon, Janet Booker Davis, Judy Weatherby, and Don Royston will be attending along with myself that meeting, so that should be good. The Western Regional is at the end of June, and I don't believe we have anyone attending that meeting. And then the annual meeting will be in October into the 1st of November. If you have any interest in attending that meeting, feel free to let me know. I don't recall right offhand how many we have budgeted. It's either 2 or 3 to attend that meeting. NASBA jurisdiction reports. The attachment to this director's report has those particular statistics for exam candidates for the first quarter of 2016. So we had a 49.8% pass rate in Tennessee, which was above the national average. Anyway, there's a lot of statistics there that you can review, and if you have questions, feel free to let me know. I'm not sure this has been, I think I shared this with the board at the last meeting, and I'll just continue to attach for your information. The new exam does launch in April 1st of 2017, so we have a little less than a year before that arrives. Testing time will be moved from 14 to 16 hours. There'll be a greater focus on higher order cognitive skills on that test. You'll still see 4 parts to that exam. There will be 1 15-minute break per section introduced that will not count against their time. So that's a big change, it sounds like. Each quarter of testing, I mentioned this yesterday, is going to be extended by 10 days beginning June 1st, each dark month, as a lead up to the new exam. And the reason for that is, as you might imagine, there's a lot of students that want to hurry up and take it because they don't want to have to sit under the new exam because the expectation is it's going to be harder. So I haven't heard any details about that, but I'm trying to educate candidates as they call. Candidates may pass a combination of the current exam and the new exam. Any combination will work. And the exam remains adherent to all the testing standards. So any questions about the exam? Y'all have already taken it, so I assume you don't want to take it again. Background checks. There was a question at the last board meeting. Thought I would just update you on whether NASBA performs background checks on our candidates, and they do not. So that's just a answer to a question from the last meeting. We did create a spring newsletter that went out yesterday via email. We've historically just been doing that once a year. We're going to try to do that more often just to touch base with licensees. If you have any comments, concerns, or suggestions for that particular newsletter, let me know. If you want to write up something fancy, I'll be glad to take submissions. The CPE audit. We did start the audit for the 2014-15 renewal period, sent out those notices on April 19th. We also sent an email to all of those selected for audit, so if we had the email address on file, then they received 2 notices of that audit. 529 licensees were selected. Renewals, as of February 1st, the $100 late fee was assessed on anyone who had not renewed. We began an effort on April 26th to reach out to folks who had not renewed to encourage them to either renew or properly close their license if that was what they would like to do. Hopefully that will help as we get into professional privilege tax assessment and people being unaware that they needed to make some change prior to being assessed that tax. Core Phase 2 requirements were established in February. Again, this is our licensing platform. Phase 2 is set to go live at the end of June, and the major portion of this is online applications for new candidates. So new candidates will now submit their application and pay their fees online. It's going to be a great improvement and add to some efficiencies in our office. So we're excited about that. I hope I'm saying this right. The Elijah Watt Sells Award. On April 13th, the AICPA announced the winners of this award. The award's given to CPA candidates who have obtained a cumulative average score of 95.5 across all 4 sections of the exam and passed all 4 sections on their first attempt and completed that testing in 2015. A total of 93,742 individuals sat for the exam in 2015, with 75 candidates meeting the criteria to receive this award. We had 2 winners in Tennessee, and those are listed in your report. Matthew K. Bishop, he's a graduate of Lipscomb University with a bachelor's in finance, economics, and business management, and the University of Memphis with a Juris Doctorate, and is employed now with HCA in Nashville. I will probably botch this next name, Syed Paul Arab, graduate of ETSU with a bachelor's in economics, and is employed with Home Federal Bank of Tennessee in Knoxville. And the last page of the report simply gives you some statistics on new licenses we've issued and the overall license population. Are there any questions?
I have a couple questions. I know, surprise. Sorry, Mr. Chairman. So actually, just a quick question. We've talked before about trying to engage younger accountants. I think we've talked before about trying to engage younger accountants in what we do. Is there anything that the board has done in the past or the staff does to send some type of letter or formal accolade or something to the people who win these awards in the state of Tennessee? And if not, is there any desire on the part of this board to do something like that? I think that recognition is pretty impressive, to make over a 95 point whatever it is on the exam on the first try. And it'd be nice if we could somehow do a proclamation or some type of board action that would officially commend them for doing that and welcome them to the profession in our state.
I'm not aware of anything this board has done, but I could be just missing something. It's my understanding that TSCPA in the past has provided some award for this particular achievement.
It's a wonderful idea, and certainly, at the very least, we ought to recognize it and start recognizing it with a letter from the board.
Exactly. I think that would be a nice gesture. Maybe even try to rope some of these younger professionals in, or earlier in their career professionals, into what we do, and let them know we're paying attention, other than just obviously issuing the certificate.
Wendy, would you sign a letter for us from the board to sign, and I'll just get it to me, and I'll.
Okay, and it would be, and you're just talking about just the folks that received this particular award.
Yeah, that's what I was thinking. Yeah,
the 2 that received the Elijah's What Sells.
Okay, perfect. We'll do.
I think it's a great idea, Gabe. Thank you.
Were there more in the state of Tennessee that had that kind of? Okay, those were the only.
The
two.
only 2 in Tennessee. I think there were 75 total throughout the country.
Okay, thanks.
One quick question. Are you aware of any other states that, in addition to the NASVA application for the exam, require as a condition to get the certificate, actually require the individuals to go through a background check?
I do not know.
I'm asking just because it came up. I forgot who asked it, but I thought it's a good point, and Ben and I can attest that to sit for the bar exam, you got to go through a background check and then a character and fitness review, actually an interview. And I didn't know if we did that in the CPA profession or not.
So you don't have to do, they do not do a background check, but the individual applying for the CPA has to certify as to whether they have an issue, whether they've had a felony, and if they do, they have to explain it.
Okay.
That's correct.
And if they, I would think that if that is ever found to have been false, then there would be an issue with then it would come before the board.
And I think it was tied into the question on wasn't there like a question for application that talks about the last 5 years?
We did, and the board voted to revise that question because I think it was in the past 5 years. Have you been convicted? Right? And the board voted to remove the 5-year, and we have done that.
Further discussion?
If I could get a vote on the dates for future meetings.
You have one future meeting date that needs to be approved. Is that correct, Wendy?
Correct. July 16th of 2017.
Okay. In your in her executive director's report, we previously approved the meeting dates of July 15, October 21st of 16, January 20th, May 5th, and July the 16th of 2017. We're trying to approve today to add to that list. I'd accept a motion.
So
Motion to second. Roll call vote, please.
Booker Davis,
Aye.
Eldridge,
Aye.
Larry Elmore,
Aye.
Gay Moon,
Aye.
Gabe Roberts,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart,
Aye.
Gina Weatherby,
Aye.
That take care of your report, Wendy?
Yes, Mr. Chairman.
Okay. Under executive committee report, keep it very short. Wendy, I believe that at that point yesterday, as part of the executive committee, you brought us up to date on the actual versus budget is the most important thing that we haven't already dealt with today. You like to?
I'm sorry. Can you ask me the question again? I'm sorry.
Okay. In our executive committee yesterday, you brought us up on the operating
Correct.
report. Would you make that presentation for the full board today?
Again? Okay. I'm sorry. Let me grab those.
It's under tab. But that's not.
Because it's duplicate or two different things.
Just you can do it briefly, just so that we've got it documented for the
Okay.
for the full board files, since all the members were present yesterday during the committee meeting.
Okay. Briefly, I updated the board on our year-to-date results related to revenue and expenses. I also discussed any variances that we're seeing that might have been of any concern. We did note that longevity was ahead of or exceeding budget, and that was related to salaries for or raises that were given to the investigators were provided in a one lump sum, and that that fell in longevity rather than salaries. Also in computer related items, we're seeing an increase there, not to budget, but compared to last year, due to the fact that our rental of our copier moved from rentals and insurance to computer related items. And I also did a very conservative projection for our fiscal year end of June 30th, and with a net revenue to reserves of a little over $18,000. And again, I feel that that's conservative. So I think this board is in a good position to end the fiscal year.
Thank you very much. Any questions?
I don't have a question on that, but I gotta digress. Either my calendar is wrong, or is the date for that July meeting right?
Let's see.
Her calendar,
My
her
calendar.
calendar shows that date is on a Sunday.
That's not going to work very well, is it?
No, that won't.
You're talking about the 17th date.
Yeah.
Yeah, July 17th.
Oh, okay. Okay, so I apologize.
Catch.
Thank you, Janet. The appropriate date would either be Friday, July 14th, or Friday, July 21st. I think I would go with the 14th.
Reapprove the dates.
Yes, sir. Probably strike the previous date and approve the new date.
Motion to correct the date.
I move that we strike the date of July the 16th and substitute in lieu thereof, July the 14th, 2017.
Second.
A motion to second. Roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Garvin, unless you know of something else that we need to report under the executive committee report, I think we've covered everything else that was covered previously.
I'm fine with that.
Move on to the next report, please.
Licensing committee.
Licensing committee, please. Mr. Eldridge.
I've asked Charlene if she could stand in his chairs to be easier to communicate.
I filled in yesterday,
Okay.
so I think
Charlene,
he's
you're
saying-
you're up then.
Okay. We had 3 issues that all involved test expiration extension. And so the first one is Heather Thompson, and the information's on your iPad to pull up. She is asking for an extension based on an illness and subsequent death of her father-in-law. And he with an aggressive form of ALS. And she's asking for an extension of BEC, which was passed in October of 2014, so it would expire at the end of this testing period. She's asking for an extension through Q3, September 10th testing window. She has not passed FAR or REG. And the committee has recommended that we ask about research on whether we have in the past allowed an extension based on the death in the family of the person rather than something that dealt with the individual themselves.
My fabulous staff has been able to track some of these things down, so I believe we have some information for you. I do have the obituary for her father-in-law. He passed away on March 24th of 2016. I also have some research done on prior extension requests that this board has done. We found one in which this board granted an extension for the illness and death of a father.
So we didn't. I believe that our intent would have been to recommend an extension, but we wanted confirmation on the death and we wanted that background. So we would make a motion that we would grant an extension to the end of the Q3 testing window.
Do I have a second to her motion?
Second.
Any discussion? Roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Second extension dealt with the Latora Cook, and she requested an extension due to a surgery that occurred in April. She has passed audit, and that is the one that's going to expire. She also has passed REG and BEC, so she's wanting an extension to the end of the Q3 testing window for FAR. And the committee recommended that we do extend her testing date or her expiration of audit to the end of the Q3 testing window. And that would be a motion.
Second.
I'll second.
We have a motion and a second. Any discussion? Roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore. Gay Moon.
Aye.
Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
The The third item deals with Natalie Hill. She is requesting an extension. She requested an extension for a year until the end of April, the April 17th testing window. She has passed Reg and BEC, but she has not passed Audit and FAR. We discussed this extensively, and some of the concern of the committee was that there was not an event that had actually occurred. Instead, it was an ongoing pain. We weren't certain how an extension was going to actually help in this matter. We looked at, we actually proposed a motion to extend to the end of the Q3 testing window, so a shorter extension, and that ended up being a tie vote. So we're giving this to the board.
I would like to just make a motion that we grant the extension for the shorter period as suggested by the committee, and hopefully we'll get a second so we can discuss it.
A motion on the floor. Do I have a second?
I'll second that.
Motion and second. Discussion?
I think the concern that the committee talked about again was that since there was an event, since it was an issue with pain, we weren't certain whether this was really going to make any difference in her being able to pass 2 parts. But I guess that would be on her.
Discussion? Call for the vote, please. Roll call, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry
No.
A. Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Ayes have it, Karen. Ayes have it.
Ayes have it. Motion passes.
And the fourth item brought to the committee had to do with the Pass Online. So this is a state-specific ethics course revision that was done by the Pass Online. They are a current state-specific authorized test CPE, and they revised and have resubmitted their revision to extend their ability to continue giving the CPE. The committee's recommendation is to return their proposal, because if you look through the proposal, there were several items that were notated by Wendy and Ms. Garvin. We appreciate the work you did in that, because I know that was time consuming, to find areas that were incorrect. And so we are asking, or our recommendation is that we send it back to them for correction of highlighted area, requesting that they find the error. And upon completion of the correction, they would be approved for 1 year limit and have to come back in a year. The basis of that was because we feel like out there we're eventually trying to limit perhaps to just one ethics through the TSCPA.
Have a motion to that effect? Was that a motion?
That was the motion without the
Do I have a
ending
second
part.
to that effect?
I'll second that.
Thank you, Stephen. Wendy?
I would like to add or ask a clarification question. If I send it back and request revisions, once we receive the revisions, would this board like to see it again, or are you authorizing me to approve it?
My opinion would be if y'all are comfortable with the content, then it would be sufficient to use.
I'm sorry, I missed the first part of your comment, Stephen.
I said my opinion would be is if they send it back and you guys are comfortable with the content, then it would be adequate to use.
Okay, so I would not bring it back to the board if we're comfortable with it.
My personal opinion would be no.
Is that in your motion?
That would be in my motion that
Okay,
we
so-
allow Ms. Garvin to approve it.
And Mr. Eldridge, you're happy with the amended motion?
Yes, Mr. Chairman.
Thank you. We have a motion and a second. Any further discussion?
I have a question. So, Mr. Floyd has, and Ms. Fitzgerald have gone kind of out of their way to talk to us about what the society is doing to try to create a gold standard, I think is the phrase they keep using, for state-specific ethics for Tennessee. And so my question is, it sounded like the intent of the committee members and the other board members that were in attendance yesterday is to reduce or limit the go-forward approval of this new course for a year, in light of the fact that TSCPA, while they aren't giving us assurances that it'll be done this calendar year, hope that they have something to present to us this calendar year. My thing is, if we send this back to them, and I agree with this, make them figure out where the corrections are that need to be made, instead of just giving them a 1 year open-ended approval, which I presume would start from the date they send it back to us, we review it and confirm it's right. Should we put some date certain on there? Because we don't want them to wait till December 30th, for example, and then we perhaps have this society is ready to launch their gold standard on January the 1st, and then we have to, for the entire year, have two specifically. So my question would be, I guess, is there any room for a friendly amendment to that amended motion, that instead of saying a year from the date of approval, that we do some date certain, and then they can decide, they being passed online, how quickly they want to try to make the corrections to get it before us, so they can lengthen the time that their course is actually out there for consumption by CPAs.
I'm fine with amending the motion to be through April of 2016. 17.
Maybe to the end of this calendar year, if the TSCPA is going to have a course by the end of the year.
It's unlikely that they're going to have it effective December 31st, but it's possible. But I think it's unlikely that they would have it and actually have it ready to go.
I mean, they could, they could always come back and ask for an additional pass online. Could always come back and ask for an extension of that approval if they wanted to. It doesn't mean we would never consider it again, but at least might limit, our thing of having a new online course with the society and this new updated course from Pass Online.
In essence, though, giving them a 6-month approval.
Yeah, or giving them an approval to some date. Maybe, one option would be a year from today's date, and then that they can figure out if they want 6 months or 9 months or 10 months or 2 months or no months,
So I'll make the motion a year from today's date. Amend the motion to be a year from today's date.
Have an amendment.
And I'll amend my second.
And we have an amended second. So, any further discussion? Call for the vote. Would you roll call, please?
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye. That's all the business this committee had.
Thank you. See, Trey is not here. Wendy, he's had to get on an airplane. So, Wendy, you're going to make his presentation for him, I believe. Is that correct?
Try to artfully convey what this group talked about yesterday. We started off by talking about recapping the legislative changes that went into effect on March 10th of 2016. Those included the removal of the requirement that the executive director be a certified public accountant. It also included some changes to the peer review requirements. This board will need to write rules for that. Going forward, we'll do that at a future meeting. And then the third item is legislative changes that allows students to sit for the exam after receiving a bachelor's degree. The next charge for this particular committee was to help establish or help promulgate a rule that would help define a concentration in accounting for those folks who do not have a bachelor's in accounting. And a rule was proposed and voted on. Since that time, I have received some additional information from representatives from Lipscomb and Vanderbilt about their concern with the rule that was approved. So I'm interested in how the board would like to move forward. Would you like me to share? Would you like me to recap what this group, what the committee voted on? Okay. The committee voted to approve a rule that would define an accounting concentration as 18 hours of upper division accounting, junior level courses or higher. That was the rule that the committee approved. So the concern that both of those universities have is they have a certain a population that will not work for. And so they are asking if this board would be interested in allowing up to 3 hours of internship hours to count towards that 18 hours that we originally voted on.
So was our 18 hours, that excluded any internship hours, is that correct?
That is correct.
Okay.
And all they're asking for, so it will help conform their programs with the limited hours they have to work with, is that, you know, the intern hours count in the overall. It's just whether we can classify up to 3 of them as a, you know, the counting towards the upper division.
Now, I think it's interesting, and I think it's imperative that we get feedback from the schools. I mean, I mentioned that yesterday. The concern that I have, and my information is super out of date. It's been a long time since I was in Oxford, Mississippi, doing this. But if you're thinking about classes being 3 hours, then that would mean 15 hours of in-course work or in-classroom work. And at least when I was in school, you had 6 hours of intermediate and then 12 hours of advanced for 4 like senior level classes like advanced and tax and et cetera. And so I guess my question would be back to the schools. What are the 5 classes, presuming that they do 3-hour classes? What are those 5 classes, and is there one that the board thinks is necessary as kind of a base level of understanding that we actually won't receive we won't give the certificate until they have the entire educational requirement met? But is there a concern about the students not having 6 hours?
And I can speak.
6 classes.
I can speak for the University of Memphis, and pretty close for UT because they're at least similar student population. We have the 2 intermediate courses, then audit, tax, and cost at a minimum. It's very difficult to be. I believe we give the wrong message to our students who look to us for the guidance on preparation. And right now, even with those courses, they walk into the CPA exam mostly unprepared for the difficulty, and it's about to get much more difficult. So, though I appreciate Lipscomb and Vanderbilt wanting 3 of those hours to be for internship, I think it's for a very small and very unique group. And I think we give a message to the greater group of students who take the exam that it's not that difficult. So they would spend a lot of money and not be prepared. And again, it's an easy thing. All of these schools changed their degrees based on the ruling a few years ago that you have to have 150 hours. All the universities and colleges did that. So all we're asking them to do is to make a change based on this law that's already passed. Again, I appreciate it, but I think they're dealing with such a small minority, and it shouldn't make that much difference to those individuals to take 3 more hours of classes that they're going to need to be able to pass the exam.
Is there and I'm asking you all as practitioners and maybe the society, is there again, because as I understand it, we don't issue the certificates until the entire education requirements have been completed. This is more of an admission to take the exam. Is there a potential harm either to the profession or maybe even indirectly to the public in, for lack of a better word, loosening the educational requirements as as a barrier to actually take the exam, even though a certificate has been issued? I don't know the answer to that, but I'd be interested in y'all's perspective.
Well, the purpose of as it stands right now, the exam is testing the knowledge base of these courses. So if we say, and this is the dilemma, already our law says that you have to have 30 credit hours of accounting. So the question is, well, if we're saying you don't need 30 hours to take the exam, then what are you gaining from these extra hours in accounting, specific to accounting? That's where you could put your internship, because that's where you would be getting your work experience, and that's what we say makes you the better accountant, the better CPA when you get out there to work. So the CPA, the internships, some maybe more advanced coursework that you could do that would help you be a better practitioner. Those would be the other courses. And so the question is, at what point do you cut off and say, okay, this is what you need for the CPA exam. This other work is going to help develop your maturity and your overall expertise. And that's where it's a difficult, where we draw that line. And you could say, well, they're going to take the exam as they're prepared. But the message that we want to give the students who are walking in to take the exam is that you need to be very well educated, knowledge-based, ready to go in and take this. And I think by making it a smaller number of hours, I cannot imagine a student walking in with 18 hours and not having all 18 hours in a knowledge-based courses. I think that's just not a good message to give out.
May I ask your thoughts on raising the number to 21 hours, but not putting a requirement on upper or lower division?
That essentially does the same thing as leaving it 18, and because 21, because they're all taking, and both Lipscomb and Vanderbilt said they counted the financial and managerial lower level courses. So whether we say it's 18 upper level or 21 with no distinction, they're going to use those two lower level courses that really are not, those two courses are for all business majors. They don't really address the CPA exam at all.
I think it's just interesting here from the educators getting their perspective. I don't know the answer. I'm a little bit torn, I guess, because at the end of the day, a counter argument could be that we don't issue the certificate to someone until they complete all of the educational requirements. And so part of me is almost wondering, do we have a legal basis to restrict how much can we restrict, put barriers up to actually take the exam, if by taking the exam alone and passing it isn't sufficient to get a certificate that we issue? And I don't know the answer to that question. That's kind of where I'm going.
Well, the legislature has the authority to do so, and they have. And it's the role of the board through the rule process to define more specifically what that is. As we kind of got into yesterday, that we have this accounting concentration, and I think it would be reasonable to assume that the accounting concentration for full licensure should be larger than the accounting concentration for taking the examination. Otherwise, what's the point, right? So that is where I think we have the authority, is it comes straight out of the statute.
And based on what other states have done in this accounting concentration, that's kind of where we're basing ours. This kind of what other states are doing that have this same ruling. And again, keeping in mind, because I've done this now for 7 years with a review club, preparing students directly to go take the CPA exam. And I know that they look to the requirement, and that's what they believe is sufficient. They feel like if they've done that, then they should be able to pass the CPA exam. So it's very important to me as an educator that we give the right message to these students.
The educator ought to also know at that time that they can learn if the internship is proper. They'll learn more than in an internship than they will in a classroom, in my opinion.
And that is true beyond the base courses. So I'm totally in agreement.
I think this is a reasonable compromise personally to drop back to 3 hours and give them the 3 hours, and then everybody's on an equal playing field, and we haven't. Remember, we went into this to try to help.
But there's so many internships out there that are not sufficient. I mean, tons and tons. Whereas when we talk about the basic 6 courses that students need to take the exam, those are solid. There's not any.
Is it not up though to the educators to set the quality of the internship instead of the board to say?
No, the educator does not set the quality. There's no way, as an educator, I cannot go into the work world and see what they're actually learning. So
can't tell from what the reports that you get back, your requirements, that this is what we expect. You don't have a guideline set up.
Oh, we have guidelines. They have to do accounting work, but accounting work could be anything from checking numbers to, I mean, how many interns actually go out and learn cost accounting from A to Z? None. Once they have taken cost, they can go in there and learn a lot more about cost, but they can't learn the base knowledge of cost in an internship.
By the same token, when they come out, they can't, into my office, they can't reconcile a bank account either, and they've been in the classroom.
Oh.
So I think it's
it may work both ways. I'm not saying that all our professors, but again, I think we're talking about we didn't have the largest universities who deal with the majority of the students, other than my representation. Lipscomb and Vanderbilt are talking about 2 very small programs. One has 30 a year, one has 70 a year. They're very small. And they're also talking about unique students who are not, these are non-traditional students who have lots of business experience. Very, very unique cases. And the majority of our students are not those students. So I don't think that asking them that they all take 18 hours of upper level courses before they walk in and sit for the exam is too much.
I happen to agree with Charlene on this. If anything, I think the 18 is too low. I mean, it could easily be 21 or 24 when you go back and think about what the curriculum that we took when we were in school. And in regard to internships, I guess I'm not a big proponent of internships, but we have internships in our firm, have for years. But even depending on the timing of when you do that, there may not be enough work. You're looking for things to do to keep interns busy. They may or may not get assigned to some good work. I mean, there's just too much variation in what you can learn in an internship, I think, and I don't see how the universities or the college professors can control that. I mean, there's just no way. And so, I mean, this is probably something we could debate the rest of the day. We can have another long day today if you want to, but I think Charlene's right on.
Your report yet. Well, be quiet.
I have been forewarned. So, but I would like to see us move on. I think we debated this a long time yesterday, and I think I heard Vanderbilt's comments, heard Lipscomb comments, and I think this is more of a problem for them to address in terms of their curriculum and how they present their programs to the students. Because if you wanted to poll Tennessee Tech and East Tennessee State and the University of Tennessee and UTC, I bet you they've got some issues or exceptions. So I don't think we can solve all those. I think we need to do what's right, for the accounting profession and the students as a whole. And so I think the recommendation of the 18 hours is what we ought to do.
in fairness to full disclosure, East Tennessee could live with 17, but in most places it would be 18 quotes. So maybe Charlene's got the bigger picture, and I'm worried about the ones that showed up. So, but I'm trying to find that balance.
You found it, Don. Let's move.
Okay. That's why we have we have any further discussion? Did I hear a call for the question?
Call for the
No, we're just going to vote. There's no further discussion. Do we have a motion?
Mr. Wilson, if I may interject, troubling thing for any attorney to tell their client is I have a surprise for you. This instance, however, is a good surprise. Yesterday, I indicated that I did not think we could get a rule addressing the admitting the examinees prior to receiving the bachelor's degree before July. However, I had an idea yesterday stemming from Mr. Roberts' discussion of the word admit. I ran it by my manager. We drafted it this morning, had it amended while we were in hearing today, and I have a presentation to give to you. So, Ms. Huntsman, if you could hand those out, please. I think this is good news.
to you, Ben. That is awesome because we gave it to you very late in the day. We appreciate that work.
That was yes, between 6:30 last night and 6:45 this morning.
Was that between period 1 and 2 or 2 and 3 of the game last night? I don't know.
I didn't even watch the game. So as you receive these, no, ma'am, I think we should vote on all of it as a whole because I've now put it within the proposed rule filing form. If you turn your attention,
So this incorporates the two. So we have one. So we're handling all this at one time.
Yes, sir.
It incorporates the 18 hours that we.
Yes, sir. It also incorporates the denial of internship semester hours. So if you look at page 2, the first rule amendment is identical as yesterday. If you go down to the all red section, which would be a completely new rule, or it's amending an existing rule, but still. The last sentence in the first paragraph states semester or quarter hours from internship programs may not be applied to the 18 semester or 27 quarter hours in accounting required by this paragraph. And I believe that is in accordance with what the committee voted yesterday. Now, the new sections are sections A, B, and C. Shall I read them through, or you guys just want to read them to yourselves?
Read them out loud since Stephen's not
Stephen doesn't
here.
have it. An application to sit for examination may be filed, processed, and approved prior to the completion of a baccalaureate or higher degree so long as the applicant submits materials with the application that demonstrate that at the time of the first examination, the applicant will have a baccalaureate or higher degree with the hours of accounting education required by paragraph 4. That's the paragraph 4 just above it. B, a certificate of enrollment and certified transcript from the educational institution demonstrating that the applicant will have the required degree prior to the first examination shall be sufficient documentation to demonstrate that the applicant will have a baccalaureate or higher degree with the hours of accounting education required by paragraph 4 at the time of the first examination, provided, however, that the board or its designee may accept such other reasonable documentation as an applicant may provide, properly demonstrating that the applicant will have met the requirements of this paragraph prior to examination. C, no credit will be given to an applicant for an examination if that applicant fails to successfully obtain a baccalaureate or higher degree with the hours of accounting education required by paragraph 4 prior to the time the applicant took the examination. I think this may be what we were looking for yesterday.
Exactly, yes.
Exactly,
Great.
sir.
Great job. Yeah.
If you could now turn your attention to, if you're going to want to vote to adopt this, you're going to need to also incorporate the regulatory flexibility addendum located on page 5. If you could all just take a moment to read that.
Or what is page 5? How does that fit in?
Page 5 is what we have to file with every set of rules, and the board has to adopt that as a statement as well. When we did rules back in October, I read one into the record, and there may be an economic impact statement that I might have to have you approve at the next meeting, but that will not impede this from going ahead and becoming routing and going through the process so we can get this thing moving.
Stephen, I just sent you this via email.
I just got it. Thanks.
Are we also approving?
Excuse me, go ahead.
Are we also approving this additional information, the page 7 too? Page 7 and.
No, ma'am.
Okay. Just.
Oh, I mean, you can approve the thing as a whole, sure. That's kind of, it's like.
Take care of our gap children. I'll call them the sheet of where this doesn't affect them.
No, sir. In addition to that, I spoke with Deputy General Counsel Driver about this. In the past, if there is an existing statute or rule already divesting authority to the board can then defer that authority to Ms. Garvin. Because this is not an existing rule, there's nothing that we can do about that. And so, unfortunately, those gap children, I believe as you stated, may remain in the gap until they satisfy the educational requirements.
Well done. Did you get any sleep?
Yeah, I actually did not
You just
draft
got a good
this
team.
until this morning, and I will take credit for the bones of it, but the eloquence I will have to give to Deputy General Counsel Driver.
Great job to all of you.
It's legal's opinion that this should be able to pass the Attorney General's office and is in compliance with the statute.
Thanks to Gabe for coming up.
Bring it up. Huh?
I accept 0 credit and defer it all to Commerce and Insurance because, once again, they have proven to give us incredible legal support.
I had a chance to read the documents.
Yes.
I would entertain a motion for approval as presented, and that takes care of both problems.
Make a motion that we approve Mr. Glover's proposed rules red line.
Second.
Motion and a second on the floor. Any discussion? I'd ask for a roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore. Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Now, this is passed then, and it's got to be approved by the AG's office before it goes into effect. Is that
Yes,
correct?
so there's a fair amount of routing and reviewing that's going to happen over the next few months. And then once all that is completed, I think it will post at the Secretary of State's office. If there's not, I think, 10 members of the public who object or have questions, or an organization of 10 members or more, then after a certain time period, I think it's 50 some odd days, then it becomes rule. If, however, those individuals do object to it, there may end up being an opportunity that we have to go and bring this to a rulemaking hearing. So that might slow it down. But at this point, we can go ahead and start and move these things on.
And it's my understanding that in the meantime, the students are going to be required to have a baccalaureate degree, as well as 24 hours of business and 30 hours in accounting.
They have to have a bachelor's degree in accounting, that would qualify, or if they have a bachelor's in something else, they have to meet the 30-24.
Okay. Thank you.
I noticed on page 3 says something about a signature if required. Do we need to do that, Ben?
No, ma'am.
Okay.
What will we do about publishing this for particularly the schools that have been in question on what we've done?
Probably want to wait on that until we start getting it through the process and getting it reviewed. It will be published for the public review, post review by the governor's office and approval by the Attorney General.
What about communication back to?
I can advise them that we are moving forward with rulemaking, but that currently we are operating as we have been for the past 6 weeks or so.
We can provide them with a draft, but it is a draft, and it is not
that's fine.
in force.
Can we do that so that they understand because when we've got a fairly heavy pot stirred with communications going. I mean, and I'm just asking for guidance.
I would prefer to, if people ask, I don't really want to try to communicate.
I don't mean a blast. I mean
Right, just if
to the ones that have been interested
right.
and been communicating with us.
Yeah.
We've got
If
3 or
legal-
4 that have.
I think we can make arrangements.
Okay, thank you. I'll leave that up to the professionals. You're welcome.
There was no other business for the Laws and Rules Committee.
Thank you. Mr. Stewart, I believe it is your serve.
I've been forewarned, right?
She's already stirred enough pots over here and killed enough horses that you don't have any time left.
Everybody has been furnished a copy of the legal report. Mr. Glover, do you have something to say starting up?
Ready?
Getting ready for what?
The committee met yesterday and in essence approved or recommended approval to the board of legal counsel's disposition on, there are 34 cases here. They recommended approval on really 33 of those. I believe case number 15, we do have some change to make to that case. And then there's one case, number 30, that Mr. Roberts needs to recuse himself from. So what I'd like to do is go through this real quickly since everybody was here yesterday, and then vote on approval of the disposition of all cases excluding number 15 and 30. And if somebody wants to slow down and revisit any individual cases, well, just speak up. But again, the cases are grouped into groups based on recommended disposition. Cases numbered 1 through 10, they have been investigated. The complaint's been investigated. Everything's straightforward. Legal counsel is recommending closure of those cases. And again, our committee agreed with that recommendation. Case number 11 is a recommendation that the complaint be closed with issuance of letter of information. Again, our committee agreed with that recommendation. Cases number 12 through 15 are cases where legal counsel is recommending to close the complaint upon the issuance of a letter of warning. The committee agreed with legal counsel's recommendation on cases 12, 13, and 14. Again, case 15, we'll come back in a minute and talk about that one specifically. Cases 16 through 24 are cases where we talked about each case individually, the facts, the circumstances, and the recommendation. Those are generally cases where legal counsel is has recommended a formal hearing for revocation of license with the authority to settle with a consent order based upon the payment of a civil penalty, monetary penalty. Again, our committee recommended approval of legal counsel's recommendation on all of those cases. Cases number 27 through 34. Again, those are representations where they may have been a litigation monitoring status or some other issue, but there is new information, the litigation has been settled, or something new has come to light. But basically, legal counsel has recommended on those cases that they all be closed, with the exception of case number 34, which the recommendation there originally was to for revocation of the recipient's CPA license. The recommendation now, based on the new information, is that we not revoke the license, but we do give the legal counsel the authority to settle with a consent order upon the payment of a $10,000 monetary penalty. So Again, we talked about these in detail yesterday. I think everybody was here. Does anybody have any additional comments or questions or anything on any of these? If not, I would like to move on behalf of the committee that we accept legal counsel's recommendation for the disposition of cases numbers 1 through 34, excluding case number 15 and case number 30.
We have a second?
Can I just ask one question on number 34? What was the basis of the 10,000?
There were 3 different complaints, multiple months of unlicensed activity, multiple clients not receiving their files in a timely manner. We can do $0 to $1,000 per violation per day, and this is dropping the bucket in what we could have done.
I believe also the respondent has indicated a desire to settle this
That's
thing
correct.
and pay the $10,000 penalty. Any other questions?
I'll second the motion.
Motion and a second on the floor. Any further discussion? May we have a roll call vote, please?
Janet Booker Davis,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Gay Moon,
Aye.
Gabe Roberts,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart,
Aye.
Judy Weatherby,
Did you get my vote? I get my phone. I couldn't click over.
Yes, sir.
Thank you.
Okay, with regard to case number 15, I'm going to ask legal counsel to maybe recap for us what the change was yesterday. I think he took better notes than I did. And
The recommendation I have from the committee for that was approved by the committee is as follows. Formal hearing for the revocation of the respondent's CPA firm permit with the authority to settle via consent order upon the respondent's removal of the offending advertisement. The removal of the offering of audit, review, and compilation services from the respondent's website, or enrollment in peer review. And I believe it's called A&A. It's the free one.
No,
No A&A.
Yeah,
No A&A. Sorry.
The one item I would like to make sure the board knows, and something that came to my mind after our discussion on this yesterday. If a firm enrolls in the peer review program as a no A&A firm, and they decide to issue a preparation engagement under the new SAR standards, if they are enrolled in the program, they would be required to have a peer review. Other folks are able to unenroll and forego the peer review. So just want to make sure everybody knew that did not come to my mind yesterday. Does that make sense?
Yes, but so then in this letter that goes out, all we need to do to be clear with and be fair to the respondent is that we need to spell that out. Here's the way it works, and here's what you're going to.
So are we saying that it actually could be at a cost as a result?
Correct. And that's what I wanted to make sure everybody understood.
If he goes into that type of practice.
If he accepts that type of engagement
Right.
where, let's say he didn't have the information on his website and he decided to accept and perform a preparation engagement, our laws do not require a peer review for that level of service right now. But the AICPA requires, if you are already enrolled, you either have, and you perform that type of engagement, you have to have a peer review or you need to unenroll from the program.
Do we know if this particular person has that type of?
I have no idea.
I don't think it's as simple then as it was when we were talking about it yesterday. We may need to reconsider because there was, yesterday as we understood, there was no reason for them not to be enrolled. But now we we understand there may be actually a cost to that firm.
But there is still a no-cost option, which is to revise your advertising on your website.
Exactly.
But if he did that, Gabe, I think the only revision, he could still offer compilations. Because, I mean, is that, or I guess under the new SARS, preparation is not deemed to be a compilation?
Correct. It is a step below the compilation. There is no report issued.
Okay. And I believe our committee voted to move forward on the basis of, it's just been described by legal counsel, so I guess that has to be, I have to make a motion to that effect on behalf of the committee. So we need a second to that motion.
Second.
And then okay.
Motion discussion. Any further discussion on it? Part of this.
Well, I think, I personally believe the individual, the respondent is right on his position on this, and I mean that's why we vote as a board. I guess it's a more majority decision, but if I were him, I would certainly ask for a formal hearing on this because, and again, it gets back to you say, well, he's got it on his website. You know, I think Larry used the example yesterday of, you put on your website, we do all federal and state tax returns. But if somebody comes with you with a return for the state of Hawaii and you don't have the software, you know, you got to make a decision of whether to take that service or not, based on the economics. You know, if it's going to cost you $200 to get the software, and then somebody's going to spend some time figuring out what the tax laws in the state of Hawaii are, and you can only charge $150 for the return. It doesn't make any sense. So you may forego that one. But is that misleading? The other example I thought of last night is one that you have a lot of firms in this country that are registered firms with the Public Company Accounting Oversight Board that choose not to do any public company work. And the reason why, if they do public company work, you've got to have an inspection by the Public Company Accounting Oversight Board. And you talk about a headache and something that's costly and painful. But that's why so many firms have gotten out of that business, but they've chosen to remain registered firms with the PCAOB, and they may put on their website that they are a registered firm with the PCAOB. It's a marketing thing. You know, and so, or I mean, how's that different from that? You know, they can at any time, if they're a registered firm, decide again they want to do SEC work.
Until they do, they don't have to have an inspection.
That's right.
I guess
that's right.
I don't know anything about I know a little bit about the PCAOB, but so I'm asking this question as a legitimate question, not as a gotcha question. But wouldn't your argument, the last piece of your argument, actually support the fact that this person needs to register under the peer review piece? Because what I understand is the analogy is that they're registered with PCAOB, but choose not to provide the services that require to have them, whatever the peer review is. And here, the person is offering to provide the services, but is never registered to do it. So to me, it seems like your second point actually supports us taking the action that we're talking about taking. Maybe I'm wrong and misunderstanding it, but maybe I don't understand it. So if you could explain that to me a little bit better, that would help me.
Maybe I'm wrong, but I'm looking at it as the registration here is having a Tennessee CPA certificate, have met all the requirements and qualifications. I mean, just like you have to do to be a registered firm with a PCAOB. We've met all the qualifications and all the registration requirements, but because we don't do any of that work, we don't have to have the inspection. And that's kind of what I see this is. This guy's, he's met all the requirements. He's ready to go. He's ready to do it. He's just waiting for the circumstance that will economically justify getting into that business. You know, and I don't see anything wrong with advertising for that because you're looking for opportunities.
So in your piece about the PCAOB, if you're a firm that's registered with them to do whatever it is you just said, I'm sorry to understand that because I don't practice. Is there any other regulatory hoop they have to jump through, or do they just let the PCOB know, hey, I'm accepting this engagement, and so as a result, you need to put me on your review list?
Or if you're a registered firm, and once you do any public company work, that triggers the inspection cycle.
And so I think where I see the analogy breaking down in this certain case before us is that that's not the same, because they don't just say, hey, peer review, I've done something, come get me. They have to first register for peer review and then say, hey, I've done something, come give me a peer review. So it seems to me like in our current case, they haven't checked every single regulatory box because they have not enrolled in a peer review program. And maybe I'm making a point over something that doesn't matter, but that's just kind of how I see it.
I think there.
See, I think you should have just left it with my tax return example and just moved on.
Okay.
Be quiet.
Yeah.
Yeah. Give deference to you all to do it. I'm just trying to make sure that I'm not making a wrong. Because here's the deal: like I'm looking to you all to make sure that I'm not going way off a different side street that doesn't matter. So I'm legitimately just asking that question to make sure that I understand that I'm not doing that.
I mean, Gabe, I just think that if we do the thing that's been suggested here, I think this guy will beat us on this. I mean, I don't think he has broken any law. I think that he has set himself up to where he can get into that business, actually do that business. I mean, he's offering those services, but he could choose to actually do those services at any time. And when he does that, he's got to take on another layer of costs, I think, which is the peer review cost.
So, Casey, are you saying you think that everyone should do this?
No, I think everybody ought to offer these services and do the services. I mean,
But you see what I'm saying? If we're okaying what he's doing, then we're saying it's not misleading advertising, and everyone should do it.
I think I can just see a lot of situations out there. I can imagine myself trying to start a new firm and trying to grow that firm, and it may be that my clientele initially is going to be primarily tax driven or bookkeeping services. But I want to grow my firm, and I want to get into these other services, and I don't want to do it for one $200 client or $500 client. I want to, if I have the chance to take on an audit that's $30,000, yeah, now I will stick my toe in the water and begin to offer those other services, and that triggers a peer review at that point.
Couldn't he say that he's capable? I mean, in his advertisement, he could say capable of doing these others. I mean, he could be more specific.
Yeah, but I don't think that what he's done is wrong either.
I agree with Casey, and I'll go with whatever the majority rules here, but I agree with Casey.
Let's call for question. Do I have a second?
Second.
Any discussion?
Can we just restate what the final motion is that we're going to vote on?
Do we do the
I believe the motion was to approve the recommendation that the committee approved yesterday.
And that was just to issue a letter of...
No, there was for a formal hearing for the revocation of the respondent's CPA firm permit with authority to settle via consent order upon the respondent's removal of the, in essence, offending language from the website or enrollment in the peer review, no ANA.
I would think if we vote on the call for the question, then we'd have to vote on that motion, which has been made and seconded. And if that motion passes, we're through. If it doesn't, then we got to go back to a square one. Yeah.
Okay. Vote on the call for question, and roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Motion passes. We're voting on the motion now. Further discussion or not? I guess we've had all the discussion. That's what we were doing. So, vote on the motion and roll call vote, please.
Janet Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore, Gay Moon,
Aye.
Roberts,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart, Judy Weatherby,
Motion passes. Anything further? You got one more case?
Yes, we have to vote on case number 30, and there's no change to that case. It's just a matter of Gabe Roberts has to recuse himself from that. So, again, on behalf of the committee, I make a motion that we approve legal counsel's recommendation with regard to case number 30, which is to simply close the complaint. It's a motion.
I have a motion on the floor. Do I have a second?
Second.
Any discussion? This will be would you call for the vote, please? Roll call vote with Gabe Roberts abstaining.
Janet Booker Davis, Stephen Eldridge,
Aye.
Larry Elmore, Gay Moon,
Aye.
Don Royston,
Aye.
Charlene Spiceland,
Aye.
Casey Stewart, Judy Weatherby,
Motion passes. I believe there's two other items on the agenda to update us on the legislative update, Wendy. And while you're doing that, there were actually two others that we looked at yesterday, just so that we update it for public record. On the let's see, CGMA designation and the evolution of peer review. Those are informational, but I wanted to be sure we got it on the record.
Want me to discuss them?
Yes, just quickly on those, just let people know they're being handled.
Okay. Yesterday, I updated the board on the use of titles and designations. Specifically, we talked about the CGMA designation that the AICPA began offering to non-CPAs in the fall of 2015, and the concern that our statutes actually prohibit the use of such designation because it uses the word accountant. The board recognized the concern and reviewed the law related to that.
Thank you. I just wanted to make that a part of the public record.
The evolution of peer review, the board was brought up to date on a recommendation or discussion paper that the AICPA has released regarding their desire to evolve the peer review program from what is now 41 or 42 administering entities to 8 to 10 administering entities. Most likely that would mean the state of Tennessee would no longer, the Tennessee Society of CPAs would no longer administer a peer review program, and we may see those firms in Tennessee be administered by either another state or the AICPA. This is an ongoing discussion, and no immediate decisions are necessary, and I believe the board just decided we would monitor at the upcoming regional meeting and bring any discussions needed back to the next meeting.
You have any legislative updates?
Actually, before we move to that, I believe in the legal report, we had the letter of caution discussion where we talked about some cases in which folks were self-reporting discipline in another state, in which they received some sort of reprimand or minor penalty, and the request of staff was to issue those particular folks a letter of caution. So I provided the board a sample letter and 3 cases that are in that particular, or 3 complaints that are in that particular status right now. So I believe what the committee discussed yesterday was approving that process and the letter to be used.
Say that again, Wendy, just.
Okay. Maybe if you'd like to refer to your iPads, it might be helpful. Let's see.
Letter of caution draft.
Yeah, and then there's a list of 3, and I'm trying to remember what I titled it. Okay, so staff recommendations for a letter of caution, and then letter of caution was the sample letter. So we still would like to bring all of these to this board. That's not what's in question. We are, there is another board under regulatory boards, the architects and engineers, who follow this particular process in which staff actually brings these types of complaints to the board. They don't ever really make it to legal, which is why they're separate from the legal report. So staff receives these, they want to keep them on file, so they bring them to the board and request that they be closed with a letter of caution. We would send these individuals a letter of caution. It basically indicates we are aware of this situation. Please use caution in your practice in Tennessee.
Actually, would open a complaint on these that just would not make it to legal? Or?
Correct. So we would open the complaint, and the reason we would do that would be to have this information in their license file. And we don't ask for a response from them because they were the ones who provided the information. So we would simply open the complaint, and then I would add them to a report and share that with you at the enforcement committee each meeting. So this time we had 3. Those never went to legal. They did not, consider an investigation or anything in these matters.
How would they be reported to the board? They're not part of the legal report.
So my suggestion was that staff, that would be me, share them with the board in a staff report rather than a legal report. Now, if you would prefer them to go to legal, let him take a glance at them and just include them in the legal report, we can certainly do that as well. So mainly what we're asking today is the best way to approve this process or to handle these.
I don't think we actually made any decision on this yesterday that I remember. I guess my thought on the thing, we'll put it in the file and it's going to be a part of their record, is segregate them on the report to make it clear we don't have to take any action as a committee, or that's just a suggestion.
If that were a motion, I would second that motion.
Well, I'll make it a motion then.
I second that.
While we're talking about motions now, we've got the letter that they've approved as a draft, and the idea if we can handle that all in one, it looks to me like it's a fluid way to do it, and I'm in agreement with you on it.
Need to add to my motion that we approve the draft of the letter that's in here.
I think
Okay,
that saves us.
so done.
I'll second that as well.
We have a motion and a second on the floor. We got any discussion? How about our last vote except for adjournment?
Annette Booker Davis.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Charlene Spiceland.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
One last legislative. I know we've recapped the legislation that passed. I've been advised by the department that this is the time of year, if there are any cleanup, minor things we want changed in our legislation, they certainly can carry certain things in their department bill. And this would be the time to make any suggestions. Typically, I don't believe this board has made such suggestions. Typically, the profession, the society, does most of that. But I wanted to give the board an opportunity to discuss anything they might be of interest that they would like the department to.
Is there any way we can use that to clean up the Gap kids?
Possibly. I mean, the department is well aware of the issues created from the past legislative session and passing of this particular bill. Whether or not they're going to move to clean that up or not, will permit TSCPA, which, as you know from yesterday's, Brad's not here any longer, but also well aware. Even so, we're talking next April.
The process is going to work itself out.
Someone's going to fix it, whether that's the department or whether that's TSCPA or whomever.
The time factor is going to play anyway.
You're just going to move and forget it, aren't you?
Well, yeah.
Just think what damage you can do in Massachusetts.
I know. I can't wait.
Can I sign her reciprocal? Send her on.
Is there, would this be the time to consider possibly having a background check done for an applicant, CPA applicant? Or
That's up to the board to make a motion and decide. As we discussed earlier, there is already a reporting requirement on an application for an applicant if they have a felony in any ever.
I tell you, just a further comment on that. People charge for doing background checks, and if this board were to recommend that we do that, that's going to be an expenditure on the budget.
You'd have to raise the fee for the CPA exam to cover it. It would be more than just a passing.
And we also have statutes and rules on the books that if an applicant uses any sort of deception or fraud on their license application, as in they don't report something that they should have, then that would be grounds for revocation.
Right.
Anything else to come before the board?
Can I make a quick statement? Again, surprise,
You
surprise.
may.
So, as a member of the legal committee, I forget that, what is the committee? Enforcement committee? We go through the legal report in great detail. I mean, yesterday was a perfect example of that. But we still rely really heavily on the understanding that the allegations that are actually brought forth on the legal report have been thoroughly investigated, and that evidence actually exists to support those allegations. And on this basis, we give legal counsel a lot of authority to settle things outside of formal hearings so long as this licensee pays a civil penalty most of the time. But after today's case, if I had heard, if this case had been resolved by the individual paying a civil penalty to avoid a hearing, I would be a little bit shocked at the absolute lack of evidence that was put in either in testimony or in the file. And so I would make a request, first of all, for us to have some additional training for our investigative staff so they understand what exactly it is we need to be evidence that supports allegations. And if evidence can't be found, that the complaint be dismissed. I think we have such a big hammer as a regulatory body, and I think we got to be very judicious in how we use that. And it just pains me to think about if this similar instance had happened in any of the last 4 years, when we have 30 or 40 or 50 things we agree to in committee, if a similar situation like this had existed. And so I would request that we put some efforts into the training of the investigators to really get the evidence to understand what needs to be there to make the trial lawyers successful in presenting their case. And then I would also ask that the litigation, which we've had incredible legal support from CNI, and I don't mean anything by this other than to say we also ask that the litigators that are charged with, you get a case and you got to try it. It is what it is. And I think Ms. Ryan did a great job today. But I think that if we could really focus on vetting the evidence that was uncovered or the lack of evidence, that we not only are apprised of that and understand clearly what it is at the hearing, but also before the hearing, before the legal report is ever presented to us. So we can really have confidence in the fact that when we're effectively authorizing you to let people off the hook if they write a check to us, that in fact they're writing a check because something actually does exist as evidence that something happened that was incorrect or wrong.
If I may, Mr. Roberts, I believe the original recommendation that legal gave to the former executive director with regard to that particular case was a letter of warning. And the former executive director instructed legal counsel to change that to the $1,000 civil penalty. Would have been disposed of differently now.
Any further comments? I thank you for your indulgence over the last 2 days. I don't know that we need a formal motion to adjourn, but I'll take one anyway.
So moved.
And I think we can unanimously agree.
Thank you, Stephen.
Thank y'all. See y'all later. Have a good weekend.
You too.